to be mentioned. Item number 1.
Sudhamoy Devi matter malad. In the matter of Sudhamoy Devi malad, because one thing. Well, I'm praying for possible malad. Great for malad.
Item number 2.
Malad, I'm present. Malad, last malad there was on the register chapter 5 malad. Find the order.
New chamber applications. Item number 3.
My lord, this is my lord, my learned friend's suit. Now, there is my application, my lord, for extension of time to file my lord the written statement. Now, my lord, before I press that, my lord, there are my lord 2 other applications. One, my lord, of my learned friend, my lord, for my lord judgment upon admission, and my lord, one my application under section 10, my lord. My lord, let my lord all the 3 applications, my lord, appear. Attachment before judgment. Attachment before judgment. I stand corrected, my lord. No. But before that, my lord, there's section 10 application. I want to press that first, my lord. I have a section 10 application, my lord. Let that. No, my lord, it's not appearing. That's what I'm submitting, my lord. Let all the 3 applications appear together, my lord, on Thursday. My lord, all has to be taken up together, my lord. My section 10 is also there. My lord, attachment, my lord, I will also, my lord, make prayers, my lord, for filing opposition, my lord. That my lord will obviously decide, my lord. Let all three, my lord, appear together, my lord, on Thursday.
Other application to stay of the suit, now that happens. Now, as far as this application is concerned, my respectful submission can be allowed.
My application, my lord, let me press it at least.
Yes.
That is appearing. But what I am saying, my lord, is, my lord, let all 3, my lord, appear together. There is a reason, my lord, to that. Let all 3 appear together, my lord. We'll make, my lord, composite submissions on that. All the 3 applications.
The other application,
My section 10 and my learned friends, my lord. My lord. Now, GA number ta diye de.
One is
GA1 is my application.
Only
one is appearing.
No, that is not enough. Only GA1.
Only GA1 is appearing. Let other applications appear. next Tuesday.
Got
Deep dive.
Item number 4.
On behalf of the petitioner. Both Mother. I would also be praying for time. GA2 is my application, my lord, that is under section 47. Because our case was that the decree was obtained fraudulently. It has to be heard on affidavit, but the no, already there was a direction given for filing affidavits. Now, my lord, I am not a party to the suit. Execution application was served upon me. We are the joint administrators. Entire property that is, my lord, situated at, my lord, Chatterjee International Center, that property is commonly known as, under our administration. Administrators were appointed by the court. Now, my lord, difficulty is our reply is ready. But the thing is, my lord, there are 3 administrators, and one of the administrators' health is not permitting him to act. So yesterday, my lord, we went before the suit court where the suit was appearing for a leave so that the other 2 administrators can act jointly and file the affidavit and do other necessary things. That leave was granted, order was passed. So if Lordship gives us 2 weeks time to file reply, then a reply can be filed. Petitioner, my lord, in applicant in GA2. Lordship. And my lord, reply, kindly extend the time. In the meantime, I am grateful. Absolutely, my lord, grateful.
Much obliged.
Item number 5.
My application, my lordship. My substitution application, there is a delay of 37 days. Last date, your lordship had directed. The Lord, I have served the copy, but they have found a door locked. It is showing door locked.
Item number 6.
But I am appearing before the judgment, your lordship. But an application in GA number 5 has been served upon us. But final execution proposal. It's not the application of the award holder. GA5, my lord. But I request your lordship to direct us to file affidavit.
Not appearing in my. Here.
Yes. Send to your lordship.
But they have given the document.
They have
Yes.
filed.
You better not. We are for the judgment.
Our data.
I got it.
Item number 7.
It is a lordship. I am appealing for the plaintiff decree holder. The lordship will recall I had submitted that the decree which has been passed by the trial court.
One is my application wherein I filed this application. It has been satisfied. We have paid the decretal amount and the interest, all the amount has been paid. Meantime, they had filed GA2 stating that certain amount is due. As per us, 2 lakhs was due. As per directions of this court, we had paid the 2 lakhs as well. Thereafter, your lordship, as it had fallen from this honorable court, we tried to settle the matter. On 1st of May, the matter was taken up and your lordship adjourned it for today for the parties to sit. On 7th of May, I had sent my learned senior an email stating that if we could give a time and place for sitting, somehow as informed by my witness, he had missed the mail, stating that I had asked for a settlement and so meantime, if my learned senior is
My
available.
lord, as a
he
matter
could-
of fact, I did not see the mail of that day.
Your Lordship,
Substantial, my lord. Substantial. No, my lord, I am entitled to the money which they are saying that is paid. That's the whole story.
Lordship,
My lord,
I
it is,
had also
no,
suggested the same.
may I very respectfully submit one thing. My lord, decree is dated 18th March 2011. It has been upheld by the Supreme Court on 10th April 2017. Thereafter, 2 sittings have been held, wherein our learned friend, no, of course not, but
And his
2,
client did not participate in that.
my lord, if my learned friend agrees to a date, which should be a, as a matter of fact, my lord, you give me. My lord, your lordship will be the best judge to decide the matter in one straight hearing. I was just submitting this. Since she's saying that she sent me a letter, I haven't received a letter. Let a date be fixed on which date we can sit together. I have to get in touch with Germany. I have to get that man online, and we will sit. If we fail, then we go to mediator. Of course, I appreciate it. I appreciate it. No, I'm very aware. My lord, Mr. Sabasati Chandra is here. He's leading me.
But this is execution, no scope of mediation. No, there is no dispute. After decree, my lord, how there can be dispute?
They are telling that they have complied. They have not.
No, my lord, we will, lordship will take it up any day, even if today. My lord, kindly do not send it to mediation. It will again continue. My lord, keep it on. If the party, my lord, we had attempted settlement. My lord, the senior counsel at that point of time, Mr. Jayanto Mitra was representing the statesman. And my lord, we had gone, Mr. Khanna was there, I myself was there. We had made attempts to, my lord, and we had pointed out what the issue was. They did not get back thereafter. I'll indicate what the issue was. My lord, there is a decree saying that payment has to be made from the date of the respective invoices. Now, the decree was in terms of US dollars. So therefore, the interest is getting, my lord, calculated. My lord, lordship is aware, my lord, of the decision that the interest rate is as on the date of the decree. Because of, my lord, Forasol judgment, 84 Supreme Court, that is, my lord, the position. There is no dispute with regard to the rate. There is no dispute with regard to, my lord, what is the amount payable. Only question is what they are doing. They have paid, my lord, the adjustment has been made. There was a fixed amount which was put in fixed deposit before the registrar. Now, when that was encashed, my lord, thereafter in 8 years, my lord, they paid in 6 or 7 tranches. And then they are saying, I have paid the entirety of the principal. We are also agreeing to that you have paid it. The question is, what about the interest of this entire period of 7 to 8 years? That is the small, it's only a calculation issue. Lord, you will keep it on any day, my lord, we will give us. Not. The notes will be only regard to calculation, that's all. Correct, only calculation, yes, that's all.
Your Lordship, we have to file the opposition to their GA2. Your Lordship, in the meantime, settlements were going on talks, so we know some.
Well, there is no scope of any further pleading. They want to file affidavits, let them file it in the meantime. Because I shall show from their affidavit, my lord, more than 1 crore is payable. I'll rely entirely on their figures.
Your
Lordship.
Obliged.
Item number 8.
I appear for the petition, that's item number 8. Well, let me kindly take the last order. Well, they're just seeking in adjournment. Very good. Your lordship will rise at 12 also.
Item number 9.
Your Lordship, I am being led by Mr. Rohit Banerjee playing for a short passover.
Kindly then will a point of maintainability of this execution application. I'm sure my learned friend will answer that first.
Your Lordship, in this execution proceedings, no.
Apparent is on the face of the report.
Milord will kindly, Milord, take the supplementary affidavit. I am the award holder. And Milord, an issue was raised with respect to service of the award. Lordship, Milord will directly come to page 7, the orders which we have annexed. So, Milord, on 3rd of January 2022, this execution proceedings.
I'm sorry to interrupt. Milord, I just remind my learned friend that was not the preliminary issue raised.
No, I understand.
Okay.
Preliminary issue is with respect to whether the award is sufficiently stamped or not. That is Milord, the verbal issue which has been raised. There is no application to that effect as has been indicated by your Lordship. Milord, kindly comes to page 7. Your Lordship is at page 7. This is an application for execution of an award dated 3rd March 2017 passed by the West Bengal State Micro Small Enterprises Facilitation Council. The award is for a sum of 23 lakh plus interest. It is submitted on behalf of decree holder that there is no challenge to the said award. It appears from service report filed by the department that the copy of the execution application has been delivered to the judgment debtor. Based on this, Milord, there was an order of injunction which was passed by the coordinate bench, which will appear at page 8. Thereafter, Milord, another order was passed of symbolic possession at page 9, where Mr. Aurik Banerjee, who was appearing then on behalf of the judgment debtor, had made his submission. Milord, the second last paragraph. Mr. Banerjee, learned advocate, appears on behalf of the judgment debtor and submits no signed copy of the award has ever been served on his client. Now, I have considered the submissions made on behalf of the parties in view of the fact that the award has attained finality. Now, why is this finding coming? Because this issue has been raised not after quite a considerable period of time. Award is of 2017. There is no challenge pending against the same. I am of the view that at this stage, there is no merit in the objection raised on behalf of the judgment debtor. In view of the aforesaid, there shall be an order in terms of prayer E of the tabular statement. Prayer E, Milord, was receiver is directed to take symbolic possession of the assets. After that, Milord, an appeal was preferred. I have annexed the memorandum of appeal where no ground was taken with respect to stamping or insufficient stamping of the award. Now, Milord, kindly comes to the order of 18 January 2022, page 20, which is, Milord, the impugned order. Your Lordship, Milord, finds this is the impugned order, which was annexed with the memorandum of appeal. Now, Milord, the appellate court, Milord, passes the order at page 24. I'm not troubling your lordship with the preliminary direction observations made. Kindly comes to, my lord, the page 25. My lord, the middle portion. We notice, the lordship has it. We notice from the impugned judgment and order that the execution application is made returnable on 14th February 2022. It is usual in such proceedings for a defense to be taken that the award was not served upon the award holder. This observation is made. We find that in the execution application, there is an averment that the arbitral award was communicated to both parties on 14th March 2017. At the initial stage, this assertion has to be taken as correct by the court, subject to it being disproved upon exchange of affidavits. The second stage has not arrived. The application is only returnable on 14th February 2022. Considering the evidence before the learned single judge, his lordship taking a prima facie view and passing an order appointing a receiver only to take symbolic possession of the subject property cannot be faulted, in our opinion. This is subject to the respondent adducing sufficient evidence to court to convince the court that the award has actually been served on the appellant judgment debtor. This issue should be decided by the learned judge first upon exchange of affidavits in the execution application. Till then, the impugned judgment and order may continue, but no further order in execution be passed until this issue is decided. So, this is the last observation passed by the division bench on 25th January 2022. Now, after that, there is a stoic silence in the proceedings of execution. For abundant caution, Millard, we write to the Facilitation Council requesting them to serve the award afresh. Now, Millard, kindly come to the next page, page 27. This is, Millard, a letter issued by the Facilitation Council. This is addressed to Messrs. Onupam Enterprises, who, Millard, before your lordship, is the award holders. And they have served afresh a copy of the award. Kindly similar, this is countercopied to BESCO as well, who is the award debtor. The last endorsement, copy forwarded for information to BESCO. Here, the award, the signed copy of the award is again delivered. Now, this is, Millard, happening on 5th of February 2024. And there's a, yes, Millard, they had this contention that they didn't receive the signed copy of the award. This was their first objection. Now the objection has changed, but that objection has been met and clarified. What is significant is, Millard, that under section 34 of the Arbitration and Conciliation Act, there is a time limit of 120 days which is prescribed. That time limit of 120 days to challenge or raise any objection with respect to the validity of the award today is lost. Yes, yes. So, Millard, if I am to break the issues, yes. So, Millard, why I showed your lordship the series of the orders? Because their principal contention, the principal issue had not been given a go-by. Today, the judgment debtor says that they are alleging the point of insufficient stamping. But I have apprised your lordship that as on date, there is no challenge to the award and there cannot be any challenge to the award. That is a part of my argument with respect to the Arbitration and Conciliation Act, barring section 36, which talks about execution. Now, if I am to address your lordship with respect to 36, where the award has to be treated as a decree, then, Millard, certain question arises. The first question is that any objection has to be seen from the light of section 47. This your lordship is aware. In section 47 as well, the court will not go behind the decree. The court is only going to look at the decree or award in this case and find out if prima facie there is any objectionable grounds. Now, Millard, 47 has a limitation period. Yes. First and foremost. Yes. And the court asks some questions to me. If at that stage, yes, what has my lord come up to your lordship's notice, my lord, that if at an interim stage when I am coming up with an execution application before 2 years, then the court finds this difficulty and the court asks questions to me. But the situation is a bit different here. But the situation is that admittedly, I have come for execution after 2 years because the award was of 2017. I knocked the doors of the Honorable High Court in 2022, which was after 2 years period. So they had notice of the award in 2022 itself. The second aspect, my lord, is, so my lord, they knew what was the stamp duty, if at all paid, along with the award, which according to them was none. The situation stands same today. There is no change of circumstance. So even in 2022, the fact that the award was not stamped, along with their original contention that it was never served on them, was available to them. Now, objections for execution can only be raised under the grounds mentioned under section 47. My first objection to this verbal ground is the 47 issue must be made through a prayer supported by an affidavit in support of master summons. First and foremost, why, my lord? The answer is, if I may most humbly submit, my lord, that it is not like an Order 7 Rule 11 action. Kindly appreciate this is happening at a stage when parties have already litigated one round of litigation, and this is, my lord, only at the execution stage, where the defendant or the judgment debtor does not have much to say because he cannot invite the court to go beyond the decree. So only points which he has is indicating at a nullity under section 47. And 47, my lord, has a limitation period. And that limitation period is 3 years. So A, the objection, whatever it might be, had to be through an application. The second is that whatever objection is being raised, be it questions of fact and question of law, it must be within the period of 3 years. 47 has to be filed within the period of 3 years. There is no doubt that in 2022 January, the judgment debtor had full knowledge of the award and the fact that it was insufficiently stamped according to them. So if they had to raise this point, they ought to have raised it by early 2025 and not at this stage, which is beyond the period of limitation. So this particular issue that the award, my lord, is at page 28 is insufficiently stamped, or in this case not stamped at all, is squarely an issue under section 47. And the period of limitation being 3 years, my lord, my learned senior colleague's client cannot urge this issue at this moment. There is no application, and ex facie it is this objection is barred by limitation. Now, assuming, my lord, that this objection falls on good ears of your lordship, and your lordship, my lord, decides that your lordship is going to impound it, then this has to be sent to the collectorate, and this is going to get impounded, and this is going to be returned before your lordship to find place in your lordship's execution records. My execution petition for this ground, even if it is entertained, being hopelessly barred by limitation, my lord, will not be dismissed on this ground. My lord, these are, my lord, my most humble submissions. So first, my lord, this my learned friend may meet these issues.
I was a little taken aback, my lord, by this argument. Kindly, my lord, have a look.
Kindly, my lord, I had taken out a judgment, but I'm just trying to find out. Kindly give me a liberty. If I find out, I may submit it.
Yes. Kindly, my lord, allow me also, my lord,
Yes.
to distinguish once, my lord, his sides.
It's my fault. I should have been ready.
Kindly, my lord, have a look at, my lord, my learned friend's execution application once. My lord, my learned friend, my lord, has avoided answering, my lord, the first point which, my lord, we urged. Kindly take, my lord, the award. Push up. দয়া করে যাও যা ইচ্ছে করো যা ইচ্ছে করো kindly my lord turn to the award. My lord, the award starts, my lord, immediately after, my lord, the tabular statement. Kindly, my lord, turn to the last page, my lord, of the award. My lord, my learned friend, I do not know, my lord, why my lord has avoided, my lord, answering this. My lord, it's internal page, my lord, the awarding portion, my lord, the directions, my lord, in the last page of the award. Yes, my lord. Correct. I'm so grateful, my lord, to your lordship. Kindly take, my lord, clause 4. My lord, supplier is my learned friend's client. My lord, he was to submit his claim to me, my lord, upon, my lord, certification by a chartered accountant. And then, my lord, the question of, my lord, payment, if at all, my lord, could have had arisen. Post-award. In, my lord, the execution application, my lord will not find, my lord, my lord, single document showing that this certification has been done and this has been sent to me. So, my lord, this execution application is premature. My lord, this is what. True. My lord, I first show your lordship, my lord, the point which, my lord, very well, my lord. Kindly, my lord, grant me this one. Very well. My lord will do that. My lord, kindly allow us, my lord, a liberty. Kindly grant us a liberty. Yes, my lord, kindly grant us a liberty. Kindly adjourn it for, my lord, 3 weeks. My lord will come.
Yes.
Very well.
But
Great.
1/7 may it be the next week after that. May it be a week after. Yes. I'm deeply obliged.
Grateful.
And
to
deeply.
Grateful.
Item number 10.
Lordship, appearing on behalf of decree holder. Lordship, as per the last order, submitting the written instruction
But I'm for the judgment data.
and also hand over. Okay.
Item number 11.
Lordship, in item number 11, I am for the judgment data number 1 and 2. There is already a stay by Honorable Appellate Bench, Your Lordship, by order dated 1 April 2024 and 3 April 2024, Your Lordship. This matter can be adjourned Sanida, Your Lordship. I'm unable to hear, Your Lordship. I'm so sorry. Your Lordship's voice is not coming. I'm so sorry, Lordship.
No, are you
Yes,
are you
Lordship.
for the judgment data?
No, Your Lordship, there is another third party has filed an appeal and they got the stay in this
You are
proceeding, Your Lordship.
representing whom? You are representing.
I'm judgment debtor 1 and 2, Your Lordship, in this execution petition.
Okay. Learned advocate for the judgment debtor, number 1 and 2 is present. Is submitted by the learned advocate that there has been stay of further proceedings. In what of the decree?
Of the decree, Your Lordship, in APOT number 126 of 2024.
The proceedings of the decree, for the proceedings of execution case.
Of the execution of the decree.
Let this matter stands adjourned till 5/8/2025, 5th of August.
Grateful, Your Lordship. We'll come again if anything happens in that. Grateful, Your Lordship.
And an appeal is running in list before court number 37.
Pending appeal.
Pending.
Okay. Learned advocate for the decree holder present and submits that an appeal against the decree has been preferred and prays for time. The matter stands adjourned till 8/7/2025.
Your Lordship, I am appearing on behalf of the decree holder in this matter. Your Lordship, as per the last order of this court, the judgment debtor was instructed to file the affidavit of
Lord, it is item number 13.
affidavit of evidence
Yes, item number 13.
assets in
My
this.
lord, I am appearing on behalf of the judgment debtor, my lord. I know there has been a delay in filing affidavit of assets, my lord. It is an ex parte degree. Kindly give me 2 weeks' time. I positively file it, my lord.
The last occasion,
Already intimated them.
last occasion, how much time did you take for
My
filing?
lord, some time has been taken, my lord, but there were some difficulties in the family. Last opportunity I am seeking. I will not take any adjournment, my lord.
Your Lordship, we have given twice them the reminder of this notice.
Yesterday only they have served it, my lord. Yesterday.
Also on 24th of May. The main
24th of May was during the vacation. Yesterday we have come to know we will file it positively without any delay. Kindly give me 2 weeks' time as a last opportunity.
So the decree holder is present. Mrs. Menas, learned advocate for the judgment debtor, prays for time as a last chance to file the affidavit of assets. In the interest of justice, the judgment debtor is granted last opportunity to file affidavit of assets by
2 weeks.
3rd of July.
Deeply obliged.
By 3/7/2025, let this matter appear on 8/7/2025.
Deeply obliged.
In the event of default,
Okay, the time granted is peremptory.
Certain.
I appear, my lord, for the decree holder. Here, my lord, my lord's last order of 8th of May 2025 is in respect of for execution of a decree on the basis of a commissioner's report for mean profits. Now, they had preferred an appeal. On the last occasion, they took an adjournment on the ground of pendency of the appeal. No steps were taken by them, and it's only today they got the matter listed before the Honorable Division Bench.
It's fixed at 2 p.m. today, my lord.
So let it appear on Thursday.
On Thursday, my lord, let it appear on.
It's just not today.
Sir, could it be next week, my lord? Thursday, my lord.
Yeah, let us see on Thursday if we
No,
you
for
cannot
my,
obtain any
for,
necessary
not
order.
because of for my personal difficulty. Could it be next week?
Achha, on the prayer of learned advocate for the judgment debtor, the matter stands adjourned till
Anytime next week will come back.
Next Tuesday, my lord.
Yes, yes.
on 24/6/2025.
Grateful, extremely grateful. Grateful. Okay. My lord, friends, personal difficulty, I possibly can't oppose.
For the judgment debtor, my lord. Pursuant to my lord's last direction, I have already filed my lord affidavit of assets. But kindly keep the matter after 4th of July. May I indicate why, my lord?
Copy served, copy of the affidavit of
I'm being told that copy has not been served, but during the course of the day, my lord, it will be served, my lord. But kindly keep the matter after 4th of July. May I indicate why, my lord? Because there is a chance of, my lord, the ex parte degree from which this execution has been filed may be set aside. Is any application pending for setting as an expert degree?
13 application was allowed.
Yes.
13 application was allowed pursuant to deposit of 75% of the decreed amount.
Yes.
We are in course of depositing that amount, my lord, in the suit court.
Anyway, the decree was set aside.
Pursuant to the deposit.
Ex parte decree was set aside.
From which this execution was filed, my lord.
So now this execution proceedings have to be kept in abeyance.
Yes, my lord. Kindly keep the matter after 4th of July, my lord, because
Because you see that decree on which that execution is taken up, that has been set aside. So
pursuant to my lord, one thing may I just
yes.
indicate, pursuant to the deposit of 75%.
Yes, so that is deposited.
No, we're in course of depositing it in the application will again appear on 4th of July in the suit court, my lord.
And also the affidavit of assets.
Okay. Learned advocate for the judgment date, learned advocate for the parties are present.
Last one.
Learned advocate for the judgment data submits that an application for setting aside ex parte degree is pending for disposal.
That application was allowed, my lord.
Okay. That
Learned,
that an application for setting aside ex parte degree was allowed subject to the compliance of certain conditions, and the matter is yet to appear on 4th of July 2025. Top. In the facts and circumstances, the matter stands adjourned till 8/7/2025.
yes, my lord.
As affidavit of assets is already filed.
No.
Not yet filed.
Yes, it is. I'm being told that is modified affidavit of asset was filed, my lord, in 13th of this month. My lord. Yes, my lord. That has been filed, but it has not been served. That I have been told.
Let copy of the affidavit of modified affidavit of assets filed be served upon the degree holder.
In course of the day or tomorrow, my lord, I'll
Anyway, you serve it.
very well. Grateful to your lordship.
Item.
My lord, in 16, I beg to appear on behalf of the judgment data, my lord. My lord, we have paid them.
Decree holder,
Now-
your lordship.
Now they are telling they are entitled to more. So that is the reason this matter has come up before, my lord.
According to them, some more amount is
Yes,
due.
Your lordship,
I'll satisfy,
according
my lord.
to
Judgment.
So it's better you go for mediation. Okay. If you fail, I shall hear out the matter.
Your lordship, according to
My lord,
their affidavit of
Yes.
compliance, they've written that a sum of 33 lakhs they've already paid, I agree. And they've said as far as the balance amount is concerned, 4 odd lakhs or 3.5 lakhs, they are not willing to pay that, your lordship.
Relax.
They are not entitled.
Anyway,
I'll can satisfy.
it's better you go. If you cannot settle, I shall
Your
hear out the
lordship,
matter.
Lord,
my only request is your lordship will give us 2 weeks time before your lordship sends us to mediation. I shall also
No. If it fails, I shall take it up and you come with your written notes of arguments. Yes, learned advocates for the parties are present as part of the decree is complied with, and according to the judgment data, and according to the judgment data, the entire compliance is made, which is disputed by the decree holder. This court is of the view that this matter may be settled if it is sent to mediation. Thus, this matter is referred to mediation. Let dash be appointed as a mediator. Stop. Let this matter. Parties are directed to appear before the mediator.
If I was just praying your lordship will give us 2 weeks time before
Anyway,
your lordship sends us to mediation. I
No,
shall
it's-
also,
why you should waste this time? You utilize this time.
your lordship, I shall take instructions from my client.
Question is, you see, both
If
the
he is willing to forego that
No,
amount,
no, no,
your
no.
lordship, anyway, it
You
will be
see,
settled.
question is, if it fails before the mediator, I shall entirely decide. I shall decide the matter on merits.
my lord, they are telling that they can
If-
forego the they
Very well, you forego before the mediator. Let me see the report.
I was just praying your lordship will give us 1 week's time before your lordship sends us to the mediator.
Just check it in order.
If my client is not agreeable,
Okay.
we'll go before the mediator.
Yes. Learned advocates for the parties are present. Learned advocates pray for time to sit for discussion regarding settlement. Let this matter appear on. Okay, I'm just keeping it on 1/7/2025. 2 weeks time I'm giving.
Great.
See if you can discuss and settle it.
Lord, my lord, we'll come back on that. I am ready with the matter. Nothing is.
My lord, I appeal for the judgment data, my lord. But pursuant to my lord's last order of 22nd of May, we were required to file our affidavit of assets. My lord,
I'm appealing for the petition.
I am
Degree holder.
filing my affidavit of assets. My lord, so far as the appeal is concerned, which was preferred by us, my lord, the appeal court has heard the appellant and hearing is concluded. It was fixed yesterday for the respondent, my lord, the award decree holder to, my lord, start arguments.
So that means hearing is concluded on behalf of the
Appellant.
one of the appellants.
Yes. So it was
Entire hearing
no,
is not
no.
concluded.
So, my lord, it was fixed yesterday. They took time yesterday. So the division bench observed that they will, since they are taking time in the appeal, they will not press for further orders in the execution now.
Okay. My lord, it's fixed tomorrow, my lord. I am humbly praying for not this week, my lord.
Your learned advocates for
And
the
kindly also
parties-
take.
Parties are present. It is submitted by Mr. Dotto, learned advocate for the judgment data, that the matter is being heard out by the Honorable Division Bench.
It's fixed tomorrow. It will be heard out
And the
tomorrow.
matter is fixed tomorrow.
After 2 weeks, lordship,
Uh,
it will be over.
My lord, kindly
Uh,
keeps it
facts
next
and
week, my lord.
circumstances
And I've secured the money.
stands adjourned till 1/7/2025. The affidavit of assets file be kept with the record.
And my lord, I have also disclosed a document that we have parked the entire amount pursuant to your lordship's order in my account. That also I have annexed here. So they are secured, my lord.
Obliged.
Copy be served.
I have. Grateful, my lord. Lord, I appear for the decree holder. My lordship, kindly sees, my lord.
Item 18. Go for the decree holder.
Yes, my lord.
Appearing for the first time.
No, my lord, second time. We have served. My lord, may I file the affidavit of service, my lord?
No, I think service was dispensed with on the
Yes,
last
because I appeared on the last occasion and
appeared
you
on the
had,
last occasion.
yes.
Yes, still, my lord, we have prepared an affidavit of service. Now, my lord, learned friend has a copy of the execution application.
Yes, it has been served on that day itself. Your Lordship, I'm praying for a week time.
Okay.
No, my lord,
Learned
kindly see, kindly see.
Advocate for the degree holder and learned advocate for the judgment data are present. Learned advocate for the judgment data praised for 1 week time. In the interest of justice, the prayer is allowed. The interim order granted earlier stands extended for a period of 3 weeks or till further orders, whichever is earlier.
Till further orders, lordship will kindly make.
So interim order is which you granted earlier is
Yes,
extended for a period of 3 weeks
Very well.
or till further orders, whichever is earlier. So let this matter appear on 1/7/2025.
In the meantime, my lord, may the judgment debtor file their affidavit of assets.
Yes, yes.
Let them file their affidavit of assets. Because 70 crores is due from them. This is in respect of a mean.
You are protected by an interim order. Let
Yes.
them come on the next day.
Yeah, this is Coal India, my lord.
No, you are protected by an.
Yes, I
interim order.
know, but my lord, kindly see the quantum of the decree. My lord, kindly see the quantum of the decree. It's a mean profit claim.
Lordship, let me
I
come back
won in the
in
suit.
3 weeks.
Eviction decree passed. Mean profit
I'm
decree
giving
passed.
it on 1st of July.
I'll come back. Your Lordship, I'll come
But
back.
let them file their affidavit of assets. My learned friend will not suffer any prejudice.
Okay, let affidavit of assets be filed within 3 weeks.
Grateful. Oh, my lord, instead of 1st of July, may it be on the 2nd of July?
2nd of July, then let it be 1st of July is Tuesday. 3rd of July,
Third.
chamber day.
3rd of July. Grateful.
1st of July, 3rd of July করে দিন।
Item number 1, I appear on behalf of the petitioner, madam. But this is the condition. Certain defects were the has been cleared out. No caveat certificate is also been filed, madam.
Even if it is contentious, you see the attesting witnesses are to be examined. Without examination of the attesting witnesses, you cannot, even if there is no caveat certificate. But it has to be fixed for witness action, for examination of the witness. Because you have to examine at least one attesting witness if you want to prove the will. So let me fix a date.
Sir, I can see, I'm not, looked into this matter.
Okay.
Let me
Let this matter appear after 2 weeks.
May I please look? This is my application for substitution of the defendant in a partition suit.
G8.
G8 Lordship. Lordship, there is a
But appearing for whom?
for the plaintiff.
Plaintiff, yes. Let me see what is that application? GA? Okay.
So there's a direction upon me to serve the
You are for the plaintiff.
plaintiff, Nisar Ahmed. So 1376, actually what happened, Lordship, the suit was dismissed for default in the year 2014. Thereafter,
Paragraph you have stated.
this will file in the paragraph.
Yes, paragraph 5.
No, that is a medical reason. Page 33, Lordship, the order is there.
Page
33.
Order is on.
complete. The other.
We have served, it has kept the door locked. My suit was restored, Lordship. If you see the order sheet,
Page 33.
page 33. This is order dated 25th November 2024. Delay was condoned and Honorable Court is pleased to restore my suit. Suit was restored. Thereafter, we detected, if your Lordship will kindly come to page 41, this is a copy of the plaint. We found that defendant number 1 and 2, they have died. So we have also annexed the death certificate,
Page 13 and 40.
page 39 and 40.
Oh, this is the second substitution application.
This is the, that was a restoration.
That was the dismissal for default.
Restoration. So, no,
Substitution.
substitution, Lordship.
That is
Page 39 and 40.
page 39
And 40 is the death certificate of these two defendants, Shami Mara Begum and Javed Iqbal. And if you Lordship may also see my application on page 13.
40.
No, no,
39. Mara Begum. Yes. 39 and
so they are the legal years, Lordship.
Yes.
This has to be, they have to be substituted, Lordship. This paragraph.
When did this two defendants die?
Lordship, one died in 2012.
One died once, 17 March 2012, your Lordship. And the defendant number 2 dies first.
Lordship, with your Lordship, leave can come, Lordship. This is
When did you, yes. When did you get the intimation?
Para 13, your Lordship.
Yes, record an order. None appears for the defendant number 3. You have served upon whom? Defendant number 3.
Lordship, defendant number 3.
For whom did you serve? Service, what is the service?
Yes.
Affidavit of service.
This is the affidavit service. Serve the form. Asif Iqbal, Shaista Iqbal, and Salma Iqbal.
So yes.
Kindly come to page 41. Page 41. Asif. 8B.
The layers of defendant number 2.
1 and 2, both are husband and wife, Your Lordship.
Yes.
Yes, Asif Iqbal, Shaista Iqbal, and Salma.
Learned advocate for the plaintiff petitioner is present. The application for substitution being GA number 8 of 2025 is taken up for consideration. The affidavit of service shows that the years of the deceased defendant should not be served as the door is locked. Stop. Thus, the application is taken up for the years of the deceased defendants. Contended that the plaintiff petitioner came to know about the death of one and defendant number 2 on January 2025. Upon obtaining information about the death of the defendant number 1 and 2, the petitioner plaintiff took steps to file this application. Stop. For hearing the learned advocates and perusing the petition and the materials on record, it is of the view that sufficient cause is shown to condone the delay in filing this application.
Grateful.
Thus the delay should be condoned and this application for substitution should be allowed. Let there be an order in terms of pair A and D, the master summons dated 6th day of May 2025.
Grateful. Much obliged.
GA8 stands disposed.
Much obliged. Grateful.
But before item number 8, Lordship had taken out item number 6 in the first call, and I'm told my Lordship had kept it on 19th June. But I appear for the petitioner. Lordship may keep it on 19th June. But I had one prayer which your Lordship, if your Lordship could consider. There's only one application is listed today. I have another application, GA3 of 2023. If that could be listed along with this application on 19th June. Right.
Item 8 এটা করে দিন তো।
Item 6. Item 6. I appear for the petitioner degree holder. No, item 6. Item 6.
Item 6 এ ওই 6 যেটা অর্ডারটা আপনি নিয়েছেন? তাহলে ওকে একটু বলে দিতে হবে আর কি।
I'm told it's
do one thing, you give the slip of that, it will appear on 19.
My lord.
Better give that slip.
But I shall give the number in mention the number.
It will appear on 19.
Grateful.
Because item 8, my decree, my lords, I'm seeking execution of a compromise decree, my lords, dated 14th March 2017.
This is GA1.
Now, my lords, GA1 has been filed by the respondents or the judgment debtors saying that challenging the executability of the decree. Now, my lords, let me show to your lordships, my lords, in terms of the decree, my lords, the judgment debtor was supposed to acquire 10 lakh equity shares, which I had pledged to him against a loan, and he had sold it at a prior point of time, against which I had filed a suit saying that the selling of the pledged shares were wrong.
GA1 is to be heard out.
No, my lords, GA1 is pending from a very long time, my lords. 4 years it has been pending.
So affidavits are ready in GA1.
Affidavits are complete, my lords.
Let
It
GA1
was
be
heard
heard out.
on the last.
But we were hearing, we are in the midst of the hearing of the GA1.
Heard the GA1 on the last occasion.
No, I'm just started. It's not heard.
The simple point which my learned friend is trying to raise in the GA1 is that, my lords, the decree on a certain point of time stood executed. Now, my lords, I'll show to your lordship.
Very well,
that
I
they
let
were
me
not
make
in
my
position
submission.
to make such submissions, my lords.
Let us.
Then, my lords, let him conclude today. I'll come and give a reply, my lords. This cannot continue ad nauseam, my lords. We can keep arguing one day after another, my lords. Because this is the 2020 decree, my lords. Affidavit of assets have also not been filed. I have gotten interim protection filed and order dated 6th February 2025, which your lordships very kindly extended, my lords, 18th of However, my lords, the assets needs to come in, my lords, the decree is worth 50 crores.
Let us see.
Now, my lords, this is a
Let us see, my lord. Let us see. It is more than.
This honorable court has held that, my lords, I have restrained them from dealing amount of dealing with some of these 23 crores and my lords two properties. My lords, 6 separately. Let me show to your lordship whether the decree.
So if the affidavits are complete, you come ready with your.
It has started.
Yes, affidavits are complete, the arguments have to be heard out and written notes of arguments have to be filed. It's the points of law.
Yes, it's a.
But I have not commenced here, but I have not. I have not concluded. I had just started before your lordship.
So what is the point of law? If you can indicate, then I can address it because.
In my application, my learned friend has read my application.
So started
now it's
pleading law.
now my
Started
learned friend
pleading law in the application.
after seeing my application has changed the execution process of execution.
Whatever has been done has been done with
He
the
has
leave of
filed a
court.
supplementary affidavit
Whatever has been done.
which
There's a
he has
calculation.
practically abandoned.
Calculation of the amount due, not the. I can't alter.
And he has told the court there are two options. He has given the court two options to and given two different amounts. I have never seen this, where we throw the ball to the court. Well, your lordship will kindly that your lordship will have
I'll tell you,
from the
give
decree.
you 1 minute.
Your lordship will see it is the
It's a very large decree, consent decree, exactly.
consent decree.
Exactly.
And I do not know. My learned friend will have to indicate
Executive court cannot go beyond the.
exactly.
Exactly. That's
But the
possible.
executing court must find out
Yes.
what is the amount. My learned friend must be able to show from the decree that X amount has been given.
May I just make my submissions first? Show what amount is due and payable. Then lordship, since
I think it
it's
was
a compromise decree.
You filed your opposition
Yes.
in this GA1.
No, my EC. Lordship, I want to just show.
No, my GA1 is first. my lord.
I mean, both are hurt together. Lordship will be giving one judgment. So there will not be two separate judgments. Lordship.
If my learned friend wants to start.
I will
No, I
just
do not
show-
know. I was already in the midst of my
I
submission.
want to show what is.
Let it complete. Otherwise, there will be a confusion.
Then once you
Let him
complete
place
today,
his
we'll come and give a
argument on the
reply.
case.
Because
GA1.
the execution applicant has not yet moved the application.
No, but GA is his application.
Jesus, that is. But
What
You have
case,
not
sir?
placed your case, the execution.
I have
case.
not placed.
How
That's
is
all.
this case?
2020.
2020 execution. This.
GA is also 2020.
Oh, GA1 is also 2020.
Yes.
21.
Yes.
So that's why mother, I was thinking if I could place my execution case,
Very well, you place your
may I
case.
just show the decree and how the figure is arrived at, or she kindly comes to the compromise decree.
My learned
As-
friend should
as
not
my learned
abandon
friend-
his execution case.
Well, whatever.
He cannot change his execution.
Mr. Said, you know very well we are bound by a decree. And it is that the court is implementing its own
Then we
decree.
did not have any execution application. Then if that is so, we will just have to
Execution
throw the decree to
application.
the court.
Execution application is only the formality by which
Yes.
a certified copy of the decree is brought to the notice of the court. Execution application, there is no
And the
there is no mastery of
formality
drafting. So she
obliges
kindly
us
comes to the
say that under the decree, this is the amount decreed.
yes.
This is our obligation.
How does it matter what I say? The
Interest
decree will
calculated
speak
without
for itself.
What is the
Because
decree? That
the
has to be
decree will speak for itself.
That has to
If
be
I may
said.
say it, 100 crores payable doesn't make 100 crores payable. Decree will speak for itself. Or she kindly
So you
comes
can't
to
file an execution application
Lord, she kindly comes to the
there is no money decree at all.
the decree which is at page
After the execution. After page
which is just after the execution. It is stitched page
60. The section was 60.
the last page. It is in accordance with the terms of settlement.
page 16.
Page
Just 60.
page 60.
Just after.
Just after page 60. Yes.
Fifteen is the terms of settlement.
62 is the terms of settlement.
After that is the drawn up decree. Just after that, Lordship,
60.
The last page.
Of the term, Lordship kindly comes to the beginning of the terms, Lordship, at page 48. Page 40. আবার করতে গিয়ে ডিগ্রি তো যেখান থেকে দেখা হয় সেটা একই ব্যাপার 48 লসি kindly comes to the how 49 how is the decree, how much is to be paid. Lordship, there are 3 steps. Kindly come to paragraph 3 of the decree. Paragraph 3. Sit, no, please sit. Fully, when I need your help, I'll ask you. Paragraph 3. 10 lakh equity shares of Gati Limited have been sold by the defendant number 1, that's my client, for a sum of rupees 13.90 crores. It is agreed that the defendant number 1 and the added defendant number 3 to 6 will jointly and or severally acquire by purchase at their cost 10 lakh equity shares of Gati Limited at the rate of 1 lakh per share, starting from the execution of the terms of settlement. The defendant number 1 and the added defendant number 3 to 6 undertake that they will complete their obligation of acquiring 10 lakh equity shares within 10 weeks. The defendant 1 or defendant 1? Yes, the defendant number 1 is them. So within 10 weeks, 10 lakh equity shares. I kindly note against this, not done. Within as per this clause 3, 1 lakh per week, not done. And 10 lakh shares within 10 weeks, not done. This has to be coupled with paragraph 4. The defendant number 1 and the added defendant numbers 3 to 6 will provide all documents of purchase of 10 lakh equity shares of Gati Limited by them to the plaintiff within 10 weeks from the date of the execution of the present term. That also I am saying with full confidence, not done within 10 weeks, because these timelines, as your lordship, as Mr. Sen also rightly said, the executing court can't modify the decree. Now, such shares would be transferred within a period of 6 months from the execution of the present terms of settlement to the so that is dependent on 3 and the first 4 lines of para 4. To acquire at rate of 1 lakh shares per week, complete purchase of 10 lakhs within 1 week, and provide us documents of purchase within within the 10 weeks. So 1 lakh per week, 10 lakhs within 10 weeks from the date of term settlement, and provide documents within those 10. Not done, next stage doesn't apply. Such shares would be transferred within a period of 6 months from the execution of the present terms of settlement to the depository participant of TCI Finance with this paragraph 3, then paragraph 4, first 4 lines are in continuation of 3. The 5th line of paragraph 4, that's the second step. Such shares would be transferred within a period of 6 months from the execution of the present terms of settlement to the depository participant ID of TCI with depository participant can't be. So this is dependent on the step 1 being completed. So here the step 1 itself is not done. Now kindly come to page 50. Simultaneously with the payment of rupees 5 crores by plaintiff, that's my client to the defendant number 1. So
your obligation,
my obligation, if they fulfill the clause 3 and the first 4 lines of clause 4 within every week for the next 10 weeks, complete 10 lakhs, 1 lakh per week, give us all the documents of purchase within 10 weeks, then I have to pay 5 crores. Now, Lordship, kindly come to paragraph 5. That is the third step. The defendant numbers 1 and 3 to 6 shall pay interest at the rate of 15% on 13.90 crores on reducing balance method from the date of sale till the date of repurchase by them shall pay interest 15% on reducing balance method from the date of sale of these, because they had sold these shares in the market, till the date of repurchase by them. That is here, that is the date of sale. Lordship kindly notes, undisputed is 31st of August 2016. So 15% on 13 crore 90 lakhs odd from 31st August 2016. This is admitted at paragraph 10, page 9 of their GA.
Yes,
GA1.
that is by GA, they propose to show that it is complied with.
To make the
That is their GA.
terms more clear, it is agreed that upon acquiring 1 lakh shares by the defendants, the principal amount for calculating interest will get reduced by the cost of shares purchased. This reducing method will continue till the date entire 10 lakh shares are acquired.
Reducing balance method.
So basically from 13th August 16, they'll have to pay interest at the rate of 15% per annum on 13 crore 90 lakhs. That was the price at which they wrongly sold these shares. And now that that interest will continue till the time they start acquiring in terms of this decree. So that is the calculation of interest. Now Lordship kindly comes to the next line. Similarly, that is the same clause 6, 8th line. Similarly, on the loan given by the defendant number 1, that's my learned friend's client, to the plaintiff, amount, Lordship, the 8th line of clause 5. Similarly, on the loan given by the defendant number 1 to the plaintiff, amounting to rupees 5 crores, interest will be calculated as follows. A, from 1st August 16 till the date of acquisition of 10 lakh shares at the rate of 15% per annum. From 1st August till the date of acquisition, 15%. From the date of acquisition of 10 lakh shares till the date of refund of loan by the plaintiff to the defendants at the rate of 8% per annum calculated on 13.90 crores shall be adjusted against the principal amount rupees 5 crores. So this is dependent on, the second part is dependent on their acquisition of 10 lakh shares. Because now Lordship kindly comes to paragraph 6. This is the negative covenant, the first 4 lines of paragraph 6. The defendant number 1 and the added defendant numbers 3 to 6 agree that after acquiring these 10 lakh equity shares, the same shall not be transferred to any third party. And the only transfer would be to the plaintiff. In the event of the defendant numbers 1 and 3 to 6 failing to acquire 10 lakh equity shares, or any, this is the step 4, or any part thereof, or in the event of the defendant numbers 1, 3, 4, 5, 6, failing to make over the documents of purchase of these 10 lakh equity shares, I'm sure Mr. Tisen will show that within that 10 weeks they have made over the documents of purchase of the shares.
Definitely, it's already on record.
Yes.
But I
To the plaintiff, or just a minute, finish. Or in the event of the defendant numbers 1, 3, 4, 5, 6, failing to transfer these 10 lakh. Why surprise? You will show it. Transfer these 10 lakh shares or any part thereof to the plaintiff in time. The defendant numbers 1, 3, 4, 5, 6 jointly and or severally shall be liable to pay interest rate 18% per annum on 30. This is what is attracted in our case. Because unless Mr. Sen can show that they had purchased that at the 1 lakh per share for within the 10 weeks, 10 lakh shares, and made over the documents to us, then 18% interest will be added on to this.
I have no obligation to hand over without receipt of corresponding payment. I can only show them that the documents are there. You tender your 5 crores, then I will give.
Very well.
It's not unilateral. It's a reciprocal obligation.
Lordship, the terms will speak for itself.
Yes,
Now,
of course.
neither
That's
can
what I'm saying.
I can change my stand, nor can he change his stand. The decree speaks for itself. That's the advantage.
Reciprocal obligation.
So, Lordship, let us first see whether the terms of this decree was passed on, Lordship, on the 14th March 2017.
Signed on 8th March 27. From signing access.
Oh, this was the date of signing. So from 8th March, yes. 8th March 2017 it is signed. Lordship, let's come back to paragraph, page 49, paragraph 3. Lordship, yes, I'm coming. Lordship, kindly come to page 49, paragraph 3. So they are to acquire 1 lakh shares per week, starting from the execution of the terms of settlement. That's from 8th March. So by 9th March, by 8th of April, they would have acquired the 1 lakh equity shares.
10 lakh.
No, Lordship, 1 lakh per week. 1 lakh per week, starting from the execution of the terms of settlement.
Yes, 1 lakh per week.
So, and 10 lakhs shares within
10 weeks.
10 weeks.
70.
The first correspondence from them is
Page 74 of the GA1s.
now let's take a look at GA1.
This 1 week will
Start from the date of execution. So 8th of March 2017. So 1 week is 15th of March. Lordship, kindly comes to the internal page, Lordship, or running page. Yes, page 54. Lordship will get the date of signing of the decree. Page.
This way, I'm telling that 1 week starts from this thing, from the date of
Signing of the term.
signing of the decree.
Signing of the term, that is, Lordship, we will find that date from page 56. 56, Lordship will find the date of signing. 8th of March. So 1 week from 8th of March is 15th of March. The first correspondence from them kindly come to GA1. Let me go by their application, GA1. Where is God first?
All this is not
Oh,
there.
Lordship,
This is your prima facie case which you have moved. Now let them submit with regard to GA1.
That within
With regard to
within 15th March, they have to, Lordship, this is so the first.
That is why forget that GA. It is your prima facie case, okay, regarding execution.
By execution is a prima facie, Lordship. They have to show that within 1 week, 15th of March, they should have bought 1 lakh shares.
I will show a lot of things.
Lordship, page
My
75
ought to have
of the
mentioned
GA,
this in their execution
the first
application.
letter which comes from them is
Which has been
75
suppressed by them.
days later. The 75 days later. 75 days later. So 10 weeks is 70 days. 10 weeks is 70 days. From 8th of March, the 70 days expire sometime around 18th of May 2017.
Justify that.
Yes.
How they have, let them show within 1 week how many they have acquired, what documents, and then within 10 weeks they have given.
Everything is with them. All these documents were with them. They had suppressed everything in the execution application.
Suppression principles apply in
Yes.
execution.
It does. It does. Because you can't ask for a you can't ask
So
for any
if I
amount
have
you
it,
like to.
I have not shown it. So you will show it within 1 week what you have given me.
Let me see the GA.
Let's see. So you will
Lordship
show
will
that
be taking it up now or the next day?
now.
If you want to submit, you just submit. Otherwise, on the next day, you see, as because affidavits are all ready.
Yes, yes. In fact, I was in the midst of my submission.
You written notes of argument. Both of
Well, better let us first complete our oral submission. Otherwise, my lord, it will not be proper. I do not know, my lord, what submission will come from them.
No, I have, my submission is over. My submission is over.
prima facie, he has submitted his case. Okay.
That is over.
Over. That nothing more to add.
So from these 5 paragraphs,
If you have introduced some new cases.
No. I am only saying, suppose I was not there. Suppose the judgment letter was not there.
Yes.
Would the court be able to execute on the basis of these 5 paragraphs? Your Lordship will see the affidavit in support of the tabular statement.
They have not complied. I have said if the judgment debtor does not come and show otherwise.
How has he come to that amount? Is he not required to satisfy the court on the basis of the decree? Is it sufficient for him to say
Court has to confine within
to the decree? That's what I'm
You have
saying.
difficulty in
So much-
showing those documents, Mr. Sen?
So from these 4 paragraphs which he has placed, is it evident that this amount is coming to that amount? Where, may I ask this question to myself? Where does the decree say that there will be?
These are to be clarified in the calculation and written notes.
Exactly.
It's not a question
let
of
him show
calculation.
that he has done it within 7 days.
If your Lordship
Why?
wants a written notes, I will. But better is, my lord, after completion a written notes.
For the Mr. Mitchell.
Oh, they have complied with the decree in terms thereof.
Yes,
Show
yes,
it.
there has been a separate agreement now.
Learned advocate for the
There is no
judgment
question
debtor.
that decree has stood extinguished. That is my case.
Learned advocates.
There is a further settlement.
The
There is a further agreement.
Let this matter
And that has been suppressed.
appear on 1/3/2025, 1/7/2025, under the heading Chamber Application Adjourned.
Yes.
It may retain
Whatever
its
Lordship
position,
will they kindly.
under the heading
At
Chamber
2
Application
PM,
Adjourned.
No, kindly do not keep it at 2 p.m. But on Thursday.
2 PM.
তোমাকে তো ওখানে যেতে হবে।
Chamber matters are usually taken up.
So Lordship kindly, yes, up to 12 then may not be taken. Or Lordship kindly keep it whichever day Lordship makes up the, I'm not trying to. Lordship's roster is my lords. So Lordship kindly see whenever it commences to my lord, kindly keep it on the day as at the top or at some time. It'll be convenient, Mr. Sen. He's a very busy counsel.
Well, we take it up at 10:30.
10:30.
Okay. Appear on.
Whichever day.
3/7.
But kindly keep it at as a fixed matter on 12:30 instead of 10:30. 10:30 becomes difficult. Your Lordship will appreciate.
I have no difficulty if Lordship.
Let it be at 12:30 any day. Your Lordship will fix it.
Or 12 o'clock, then 12 o'clock. একদিন না আসবে এই কোর্টে অন্য কোর্ট ছেড়ে অন্য কোর্ট ছেড়ে আসতে পারবে না একদিন
Keep it at 11:30.
Yes.
11:30. At 11:30. At 11:30. Beautiful.
And Lordship kindly direct notes to be filed if he does not bring it.
Okay. What is learned advocates are requested to submit written notes of arguments.
This is a preliminary written note because we will have to submit a written note after hearing my learned friends.
The things will expedite. Okay.
Yes.
Yes.
But I.
No, this is my application, my lord. I am for the defendant number 1. This application, in this application, I am seeking amendment of the written statement. Lord, your lordship had given me directions, given directions to file affidavit, but I am out of time, lord, to file my reply, my lord, if your lordship extends by a week.
He's for the defendant.
I am for the defendant number 1.
You have sought for
Amendment of the written
sought for amendment
of the written
statement. To which you have filed your opposition.
Yes, lord, may I file? It was out of time. May I file? Lord,
you want to file your reply?
Reply.
Learned advocates for the parties are present. Let affidavit in opposition file be kept with the record. Let affidavit in reply be filed by 26/7/2026. 2025. Let this matter appear on 1/7/2025.
Grateful.
Number 20, my lord. Here for the petitioner in GA number 2. The lordship would remember this is that matter. GA number 2 is the revocation for grant of probate of a will. And GA 3 was disposed of by my lord. GA 3 was an application where we sent some documents to the forensic expert. My allegation was that the
GA 2 is for?
GA 2 is for the revocation of the grant of probate. And while that application was filed, it transpired that an application had to be filed to ascertain whether certain documents, which we alleged that are not the signatures of the applicant in the consent affidavit. So that was GA3. In GA3 was disposed with the direction initially that certain documents were sent and report had come.
Disposed of.
Yes, report had come. The report, I'll just place very shortly, my lord. The report is in my favor. It says that my signature, which I have said, that is not.
You are appearing for?
I'm appearing for the respondent, your lordship, in GA3.
GA3 and GA2.
GA3 is disposed. GA2.
Now GA2.
GA2, in the sense the revocation, in support of that, they had sought the handwriting analysis.
So
And the handwriting analysis.
GA2 is to be heard out.
Yes, your lordship.
Now, GA2 has to be heard out. The report says that the signature is.
And in GA2, the affidavits are complete.
Yes, everything is complete.
Lordship, the issue is the handwriting expert's report was given to me. And I was briefed in this matter only last night, your lordship, as it happens. So, your lordship, I'm not in a position to be able to address your lordship comprehensively or thoroughly. If my learned friend wishes to make arguments, then I can take down the notes and then I can respond on the next day.
Learned advocates for the parties are present. Learned advocate for the opposite party in GA2 of 2021. 6 time.
Because I wish to impeach the maintainability, your
Get
lordship.
ready. Stop. The matter stands adjourned till
Shorter date, my lord. Waiting for a long time for the report to come and all.
26/6 or 24/6?
26/6, your lordship.
26/6, 2026.
Your lordship kindly records that the maintainability of this application.
Every point will be taken.
Whatever you want,
They
what-
already affidavits are complete,
Yes.
reply is complete.
Yes, your lordship.
What more points will he add?
In argument, I will not add points.
Definitely, not today. Grateful, madam.
Grateful, your lordship.
Item number 21, I am appearing for the petitioner. Your lordship will recall, this is a very family matter. There was a probate proceeding.
Settlement.
Yes,
The
probate
matter was
proceeding.
again referred for settlement.
Probate proceeding was now that I had a talk, but only some shares have to be transferred to my client under the consent decree.
Part of the issue is settled.
Yes, everything is settled.
The
The
suit
only-
was settled, my lord.
Yes, the probate proceeding was settled, partition suit was settled. Now, my lord, this part remains. And the difficulty is, my lord, the share companies, they have their own formalities and procedure.
Go for mediation.
No, my lord, kindly, my lord, this will be great. We are already trying to have it solved. Mr. Chaudhary is
Leading in this matter, my lord.
and I have had a talk with him. I have suggested to him this. Let any of the advocate on record be appointed as special officer. They will ascertain from the share companies what are the procedures.
Third party be appointed as a special
No, my
officer.
lord, it will bear cost. I'll tell you, lordship, my client is not in a position to bear any cost. The relationship is his client is the mama of my client. So, my lord, it is a purely personal and a family matter. Some share certificates have to be transferred to my client. Only what is to be done is whatever the share company's formalities they will say, that has to be complied with. Any say in the matter. My learned friend's objection was why I have come so long. There was a COVID period in the meantime. Then he said that I had given you no objection already signed, but that objection is not
The degree holder.
both actually
All are degree-
all are decree
all are
holder,
degree
all are decree holders. So, my lord, kindly keep it on Tuesday. I have already talked with Mr. Chaudhary. He will be talking to his client. Let it appear on Tuesday, my lord. It should appear under the heading new chamber, not final disposal, because there was never any direction, nor is it necessary, my lord.
Okay, let this learned advocates for the parties are present on the prayer of the learned advocates. The matter,
That some arrangement will be entered into.
prayer of the learned advocates that some time be granted as because talks for settlement are going on. Let this matter stands adjourned till 1/7/2025 under the heading new
My lord,
chamber.
let it be next Tuesday, my lord. We are in some in pressing need. I would not have disturbed your lordship, my lord.
Tuesday, of course, there is some uncertainty whether I'll be able to come or not.
Then, my lord, Thursday week.
Thursday or something. Anyway, let it be on this thing. 24/6/2025.
Obliged.
Just one indulgence.
Under the heading new chamber.
Under the heading new
Just
chamber.
one indulgence, my lord. In the last order of 20th of May, my lord, there was a direction for service of notice upon the judgment debtor number 1. My lord, that is incorrect because I am appearing for the judgment debtor number 1, my lord. It should be judgment debtor number 2.
Okay, let notice be issued upon judgment debtor number 2.
They have already entered appearance. What further
Judgment
notice?
debtor number 2. appear করছে না appear notice দিয়েছে notice service হয়ে গেছে Oh yeah, well, if they have already served, my lord, let that be recorded, my lord.
The as judgment debtor number 1 has appeared, service of notice upon judgment number 1 is dispensed with.
Yes, my
And
lord.
2 has also been served.
As the judgment debtor number 1 and 2 both have appeared.
My lord, 2 hasn't appeared, my lord. Appear করেনি 2.
2 is his wife.
Okay.
No, Udayan Mukherjee.
Oh, I'm sorry. No. The executor.
As
Not
judgment
yet
debtor number 1 has appeared, let service of notice upon judgment number 1 be dispensed with.
And my lord, 2 be served. Judgment debtor number 2 be served
Yes,
because
sir. Can you serve judgment debtor?
I shall.
Yes.
Let judgment debtor number 2 be served.
I'm extremely grateful.
Serve him once again. I'm keeping it on this thing on the next.
He was the executor. Now, my lord, I'll tell you, Lordship, since he had already settled the matter, he does not want to be in between. I'll tell you, Lordship, it is completely a family matter. We had settled the probate matter only on that ground. They will
It's
get
a matter of 1 or 2 days.
Yes, that is what I'm saying.
Serve him and come.
Grateful.
দেখ কথা বলবো অবস্থা খারাপ আমি বলছি
কাজ করে দিন চেম্বারে ছিল
একদম করবেন একদম করবেন করবেন
May I mention one suit, my lord, for inclusion in my lord's list, my lord, in the month of July, any day convenient to your lord.
Yes.
My Lord, may I be permitted to mention, my Lord, item number 67, 68, and 69 of today's daily list, my Lord. These matters, my Lord, these are undefended suits, my Lord, was fixed for witness action today. 67, 68, and 69, my Lord, three undefended suits.
You are appearing for?
For the plaintiff, my Lord, today was fixed for witness action. Matters could stand over for 2 weeks, my Lord. Our witness will be present, and my Lord, the witness will come and depose.
You have served notice.
Lord, it's an undefended.
This is an undefended suit, my lord.
Okay.
Lord, if
It
a
was
time could also be fixed, my Lord.
On the prayer of the
No, this is an undefended suit.
on the prayer of learned advocates for the plaintiff, the matter stands adjourned till 7/7/2025.
Grateful, my lord.
Lord, if a time could be fixed, my Lord, because the witness will be coming.
7/7/2025 at 3 p.m.
Grateful.
Let's leave to mention item number 66, Your Lordship, of today's list.
Yes.
My Lord, it's a commercial suit, my Lord, which is wrongly appearing before Your Lordship. But it has to be transferred. My Lord, will kindly keep it tomorrow as to be mentioned.
Let it be released. It is a commercial suit.
It's a commercial
So
suit.
it has
Your
to be
Lordship.
released.
But it has not been termed as a commercial suit, my Lord. It's 2014 suit, Your Lordship. But the dispute with respect to the suit is a commercial dispute.
So come with the necessary application then. If you want
But
it
my
to be
Lord, will
transferred.
kindly keep it tomorrow as to be mentioned. We'll address Your Lordship on this.
Okay, let it appear as to be mentioned.
66. My Lord, tomorrow, Your Lordship.
Yes.
I'm grateful.
Any other mentioning? For orders, item number 22.
And I appear for the smile.
So in this matter, GA 14 was heard by this court.
Yes, my Lord, was fixed for orders, my Lord. We'll
Let me
also
see.
file. The arguments were concluded. We'd filed our notes as well.
No, it was. Let me see. Okay, you have filed your written note today.
No, my Lord, we'd filed it on that day itself.
No, it was not put up.
My Lord, the hearing was concluded on the 20th of May, 2025.
Okay, record an order. Let this matter appear on 20th of June 2025 for orders.
Lordship has a copy of the notes, my Lord.
Yes, let the written notes of arguments filed be kept with the record.
So we had already filed the notes of argument, my lord.
Yes, I've kept it on 20th.
Very well, my lord. So grateful.
Restoration application, item number 23.
এটা একটা পাঠিয়ে দেবেন আমাকে চেম্বারে।
Serve the
I'm opposing this application.
Yes, let me see.
May I file the affidavit in opposition?
Yes.
of November, default.
When was this suit dismissed?
On 5th
Not
of
the
November.
suit, my lord. The GA taken out by the defendant number 7 was dismissed for default, not the suit.
Yes.
taken out
GA
5th
20.
November 2024.
Yes, my lord. GA 20 was dismissed, my lord. Restoration filed within time. I'm not on that. I'm not objecting on that.
Yes.
As a fundamental point with regard to the maintainability of the application itself.
No, this restoration application, where is the scope of maintainability?
I'll indicate.
Yes.
Your
GA
lordship would
application was dismissed.
Yes.
So that has to be heard out.
I'll indicate why.
Yes.
Kindly see the cost title first. Kindly see who is the defendant number 7.
No, whose application was that?
Somebody else is filing. That is why I'm saying. Kindly sees Lindsay Hair Dressing Saloon. That is the defendant number 7. Now, my lord, kindly sees who has affirmed the application. I, Sheikh Samad. Then paragraph 1 at page 12. My lord, I'm sorry. Page 12. I, Sheikh Samad. Then paragraph 1 is I am the defendant number 7.
Proprietor of the defendant number 7.
Now, kindly sees the written statement.
No, originally it was filed by whom?
Somebody else. Written
No,
statement
this
filed.
GA. I'm just talking about
GA filed by defendant number 7.
Defendant number 7. Okay.
Now, written statement has already been filed in the suit by defendant number 7.
Yes.
It has been affirmed by the pen of somebody else as the proprietor. No, he cannot be a proprietor. There is only one proprietor. This written statement kindly permits me to hand up this, my lord. May I hand up the office copy? Kindly sees who has affirmed this. Somebody else.
When was that affirmed, that written statement?
Uh, 1965.
1965.
Yes.
So we are now in which year?
So he has not pleaded that. A, B, the proprietorship, then that means it has changed. It's a suit for eviction of a tenant.
Yes.
It's a suit for eviction of a tenant. If the original tenant has passed away, nobody else can come in without any agreement, without
Anyway,
any
let
consent.
this for that the suit has to be heard out.
Yes, but kindly
Whatever
sees-
it is, you see, somebody's application is dismissed. His application,
Yes,
you
that's somebody. That's
no, no,
probably
you address on the merits, okay, with GA application.
No, GA has not been served on me. GA, the main application which has been dismissed for default, has not been served, despite directions on 2.
Yes, let me see your affidavits.
Yes, kindly sees my kindly
No,
see the
affidavit to
statement,
this
sir.
application.
Yes, I have indicated that in paragraph 3, your lordship.
Yes.
Kindly sees I had indicated in paragraph 3 that the written statement was filed by was affirmed by somebody else as the sole proprietor of defendant number 7. Now this applicant suddenly crops up from nowhere. He has not established any right. So
and you see this so far this GA is concerned, this same person affirmed this.
I don't know. Because
Please
he has not
give him
been
a
served.
copy.
Because
Give
he
him a
has not
copy.
been served on me.
No, you give him a copy. You see who has affirmed this GA?
Simple. Come on.
You're for the plaintiff, Mr. Gupta.
I'm for the plaintiff. But yes, it has been affirmed by Sheikh Samad who is filing the restoration. But who is Sheikh Samad? How is he getting into the property?
Yes.
He cannot file an application
Order.
otherwise.
Learned advocate for the applicant, defendant number 7, and learned advocate for the plaintiff are present. This application GA 21 of 2024 is taken up for consideration. Heard learned advocates for the parties, peruse the petition filed and the materials on record. Mr. Gupta, learned advocate for the plaintiff who is opposing this application, submits that he was served with a copy of the application GA 21 of 2024, but not served with GA
20, which has been dismissed.
GA 20 of 2024, which was dismissed for default. It is further submitted by the learned advocate that the written statement which was filed by defendant number 7 was affirmed by Sheikh Hoelem, who claimed himself to be the proprietor. Stop. However, this application is being affirmed by Sheikh Samad, claiming himself to be the proprietor. Stop. Learned advocate submits that the applicant has not clarified this position. Upon considering the petition and upon hearing the learned advocates, this court is of the view that the written statement was filed in the year 1965 and this petition is filed in the year 2024. Therefore, the question, it is not sure. Therefore, there is every possibility of the change of proprietorship, which is to be justified and by the defendant number 7 applicant at the time of the hearing of the suit. Stop.
Hearing of GA20.
As well as interlocutory applications. As the applicant has shown sufficient cause for restoration, this application for restoration is allowed. Let there be. Yes. Where is the master summons?
The motion.
Where is the notice of motion?
On the record, my lord. Yeah.
Let there be an order in terms of the prayer made in notice of motion dated 13th day of November 2024. GA 21 of 2024 is disposed and GA 20 of 2024 is restored to fight.
And kindly permits us to use an affidavit to GA20.
GA20?
Yes, they have served today. So kindly gives us
Let
a fortnight's time.
Let GA20 of 2024 appear on 2/7/2025, 2nd of July.
And kindly permits affidavit in opposition in the meantime so that we can come up on that.
Affidavits be exchanged in the meantime.
New motions, item number 26. But in course of the day, the GAB handed over.
Yes, is to hand it over in course of the day.
Kindly mentions that in the order. Because it has not been served. There are two orders.
Order let copy of GA20 of 2021.
GA20 of 2024.
GA20 of 2024 be served by tomorrow.
By tomorrow.
By tomorrow.
My lord, I appear on behalf of the petition, my lord. My lord, the joint decision application filed by joint receivers paying for your lordship's leave.
Yes.
Yes, this is my application, my lord, praying for your lordship's leave regarding sale of some of the lands of the joint estate of the joint receiver. My lord, I have stated in paragraph 4 at page 23. The description of the land, paragraph 4, page 23. And my prayer is, my lord, at page 29, prayer B.
Yes, so where is the offer letter?
My lord, you know, you kindly come to page 158.
Page?
My lord, 184. Offer letter dated 20 8th of November 2024. Last page, my lord, also. Sorry. Page 184.
You are the joint Shebites,
Yes, my lord, receiver, joint receiver, party receivers.
joint receiver. Oh, right. Joint receiver.
This is the estate of the my lord Kundu Chaudhary. Receivers are my lord the defendants in the suit.
Yes, take down. You are representing?
Of the co-share.
Okay. Learned advocate for the petitioners, joint receivers, and learned advocate for majority of the co-sharers are present. Heard learned advocate for the petitioners. The petitioners in the instant application has prayed for the leave to sell the subject property of the joint estate of Kundu Chaudhary on as is, where is, and whatever there is, and wherever it is basis in favor of prospective purchaser, giving the particulars of the said property. It is the contention of the petitioners that the petitioners, being the co-sharers and joint receivers, are having the right to maintain the properties of Kundu Chaudhary estate. Stop. It is contended that there are many properties in the district of Howrah concerning the Kundu Chaudhary estate where, due to lack of maintenance, the such properties are going to be disposed of by local hooligans and property grabbers. Stop. As the properties are being destroyed by the illegal encroachers, the petitioners are under obligation to take steps for properly disposing of such property with the leave of this court. Stop. It is also contended that there are many persons living in the family who are unable to maintain their livelihood despite having their landed properties in hand. Stop. It is contended that from time to time, different applications were moved before this court and orders were obtained for sale of the property of Kundu Chaudhary estate. Learned advocate has also referred to some of the orders passed by this court regarding sale of the property. Learned advocate draws attention. is contended that after passing orders in different applications by this court, different purchasers exceeded the subject property for physical measurement. Stop. One of such prospective purchaser, namely Rupayan Comotrade Private Limited of 18 Ramindra Saroni Poddar Court, gate number 4, 7th floor, room number 703-704, Kolkata 7,01,000, discovered that under mentioned properties concerning to the Kundu Chaudhuri estate, being all the Shali land hereditaments and premises situated and lying at RS Khatian number 126, 127, 148 and 149. It is contended that the such prospective purchaser has issued an offer letter to purchase the subject property for which leave is sought to sell. Yes, which page your offer letter?
184.
184.
84.
Yes. It appears from the letter issued by Rupayan Comotrade Private Limited to the petitioners that the said company is willing to purchase the subject property for which leave is sought for at a consideration of rupees 3 lakh per katha on as is where is basis. Top. Upon considering the submissions made by the learned advocates, the petition filed and the materials on record and the offer letter issued by Rupayan Comotrade Private Limited, the prospective purchaser herein, this court is of the view that the petitioners have been able to make out a case for obtaining permission to sell the subject property of Kundu Chaudhuris, of the estate of Kundu Chaudhuri. Stop. Thus, the petitioners are entitled to the reliefs as prayed for. Notice of motion ta dekhi. Let there be an order in terms of prayer A, B, C, D, E, and F of the notice of motion dated 7th day of October 2024. EA 271 of 2024 stands disposed.
Item number 27 and 28.
Your Lordship, I am for the petitioner. GA1 is my application, Your Lordship, for revocation of grant of probate, my Lord. We have served, my Lord, the affidavit of service, filed here. It's already filed, my Lord. It is returned with the endorsement refused on all the envelopes. There are 6 respondents, Your Lordship.
Same thing has happened in respect of GA2 as well. Just come back with the endorsement.
May I give a brief background, my Lord, of the facts and circumstances of the case?
The executor has refused service.
All of them have refused service, Your Lord. Yes, Your Lordship. Executor is Dilip.
Who was representing the executor?
My lord, respondent number 1. Just give me one.
No, who was representing?
My lord, Dilip Kumar Torofdar, he is the respondent number 1. He is the executor, my lord.
No,
and
who
also
was
the
representing him? So you can serve the advocate.
My lord, what has happened is the probate has been granted all the way back in 1998, my lord. It is only in the year 2025. What has happened is I am one of the co-owners, my lord, of the property. Why I say? Because I am the maternal grandson of the testator. Now, during the grant of probate, what they have done is they have made a false affidavit of consent in my name, and the probate was eventually granted, my lord. There are suspicious circumstances. I have given a notice for partition on 7th November 2024, completely unaware of the grant of probate. I get no reply from any of the parties. Thereafter, my lord, what happens is I start causing
So you
search.
have filed a partition suit.
No, your lordship, I have not.
Or notice of partition.
I've given notice of partition because I wanted to file a partition suit. Thereafter, my lord, I caused search. Upon search, my lord, in the KMC assessment book, I see that the properties concerned are in the name of the testator. Thereafter, your lordship, when I start searching for the area and the land and everything to determine in order to file the partition suit, I come to know that there are already 2 deeds of conveyances. In those, and my certified copy, my lord, that has been obtained in January 2025.
2 deeds of conveyances.
Deeds of conveyances. Your lordship, then
So some third parties have come.
not third parties, that is between these other co-sharers, your lordship. It's a deed of gift as per the will. Subsequently, my lord, probate proceedings were also, your lordship, probate proceeding certified copy also has been obtained on 21st March 2025, and the certified copy of the deeds, my lord, has been obtained on 28 January 2025, my lord. When we have come to know in those deeds, there is a reference to the grant of probate. Once there was a reference to that grant of probate, we immediately caused search with regards to the probate proceedings. And we obtained certified copy, my lord. And now we have come up with this application, and we had also served on all the parties concerned.
So when you serve the notice of partition, you are intimated by letter.
Nothing, no intimation. We caused search in the KMC assessment book, my lord. The name of the property's owner is the testator. That is Satish Chandra Torofdar. Thereafter, my lord, what happened is we caused further search to determine the area of the land. In order to file the partition suit, I have to give the details. So while I was causing that search of land, I come to know there are 2 deed of conveyances, which are deed of gifts. In the deed of gifts, my lord, what has happened is they have referred to that grant of probate. And subsequently, my lord, we obtain certified copy of the documents with regards to the probate proceedings. And that is why today we are before your lordship, my lord. We have filed this revocation of grant, your lordship. Suspicious circumstances, my lord. False affidavit has been filed in my name. And subsequently, your lordship, several grounds of fraud on the basis of which we have sought for revocation of grant, my lord. There is a certain amount of urgency, my lord, that today, in the event if they would, your lordship, dispose of with regards to those properties or alienate those properties, because the application has been refused. It's not that they are not aware, they've refused it.
No, I can do one thing. I can give you a limited protection and grant you opportunity to serve 1 second or affix it in their premises.
My
Where
lord.
they serve.
My lord.
Give you a limited
I should be
protection.
grateful if certain limited protection is given, at least with regards to the properties concerned.
Regarding interim order.
Yes, your lordship. I have sought for ad interim order, my lord. My prayers are at page 19. And the ad interim orders have, in terms of prayer above, my lord, prayer F.
Prayer D.
And prayer E is my perpetual order of injunction, restraining
Prayer D
respondents.
is the stay.
Yes, your lordship, with regards to the property until disposal of the proceedings in any manner whatsoever, my lord. And I have sought ad interim in lieu of that, my lord. And if your lordship kindly sees the KMC assessment book at page 34, your lordship sees the owner's name, Sharad Chandra Torofdar. He is the testator, my lord. Sorry.
Yes, page 34.
At page 35 also, my lord, kindly takes up Satish Chandra Torofdar. 35 and 36, my lord. Satish Chandra Tarafdar, he is the testator, 109, Satish Chandra Tarafdar.
Satish Chandra Tarafdar is the SSC.
Yes.
And where do you get that probate?
Probate, my lord, at page 100.
No, from the KMC record.
From the KMC record, your lordship. At page 34, 35, 36, my lord. The address is on the right, my lord, 111 Picnic Garden Road. And on the next, my lord, is 109 Picnic Garden Road, Calcutta 39.
111 Picnic Garden Road.
My lord, there are 3 properties. 34 is indicating 109 premises. Premises 35 is indicating premises number 111. And premises 112D. And if your lordship also takes up the will, my lord, Bengali is, your lordship, the will is in Bengali, which is at page 116. The typed copy is at 135. 116. That is the, it's written in Bengali, my lord. And I'm right. 116, my lord. 116. That is the will, your lordship.
Yes.
And your lordship, the schedule, your lordship, will, there's a typed copy that starts from 135. And the schedule, my lord, your lordship shall find from 141.
Yes.
One 141, my lord. Third paragraph talks about premises number 109 Picnic Garden Road.
Yes, 141.
Yes, your lordship. Yeah. 142, my lord, 112D.
Now you are moving which application? GA1.
GA1, my lord, that is revocation of grant.
And GA2 is for?
GA2 we have taken out for drawing up a proceeding under section. This is an application under section 340 of the CRPC. What has been practiced before the board? All documents have been submitted about. That is why we have filed an application for drawing up a proceeding in terms of
142, 111. Ticket. And page 142, point number 2, your lordship, relates to 111 Picnic Garden Road. Thereafter, my lord, paragraph 3 relates to 112D Picnic Garden Road, Calcutta 39. These are the 3
Paragraph
properties.
3, 142.
142, page 142, my lord. This is the type of.
3.
Yes, paragraph 3. Paragraph 2, your lordship, in the middle, 4th line, it's 111 Picnic Garden Road. And paragraph 3, on the last line, number 112 Picnic Garden Road. It is, my lord, the
112D.
Yes. These are the 3 properties which has been distributed to 3 sons of the testator, disinheriting 6 married daughters and wife. I am one of the maternal grandson. My mother had died at the time of granting of probate. At that time, they had filed an affidavit in my name with a false signature that I have given consent, my lord.
You are the successor in intestacy.
Yes. I had 1/9 share, my lord.
Okay. That is Surojit Dash.
Surojit Dash, my lord.
Yes.
Lord, may I just point out one thing, Lordship, kindly takes up GA2 for once. How the forgery is appearing from the face of record.
GA2 will be taken up on the next day. Let me consider this.
Because there was my signature from the
Learned
Yes, your lordship.
advocate for the applicants in GA number 1 and GA number 2 are present. Application GA1 of 2025 seeking revocation of the
Let him pass.
grant of probate dated 21st December 1998 by this court in PLA number 242 of 1997 is taken up for consideration. Although notice were served, issued upon the parties to the probate proceedings, but yes, what is the affidavit of service?
Filed already. It's filed, my lord. It's filed.
But the
And the envelopes, my lord.
the envelopes returned with the remark refused.
Yes, your lordship.
With the remark refused. As refusal is a good service, this application is taken up for consideration. Considering the exigency and considering the grounds cited by the petitioner for revocation of the grant of probate, although petitioner may be directed to take a chance to cause one more service, but the petitioner should be protected by an interim order. So let there be an ad interim order of stay in terms of, let there be an ad interim order in terms of prior F of the notice of motion dated 19th May 2025, staying the operation of the probate of the alleged will dated 20 March 1978 or 19th September 1978 or 4th January 1979 for a period of 4 weeks, for a period of 5 weeks from date. The petitioner shall take steps to cause service upon the parties to the probate proceedings by affixing the notice on the premises where the parties resided last. You can do one thing. You can, apart from that, you can make a publication in the newspaper also.
As your lordship.
And
wishes.
also make a publication in one English and one Bengal vernacular newspaper.
Yes,
widely circulated in the locality where the testator last resided.
And before your lordship rises, may I have your lordship's kind indulgence to mention item number 59. If your lordship kindly accommodates me for this week, subject to your lordship's consideration.
59 you are appearing for?
Man, I am appearing for the special officers, my lord.
Lordship, Mr. Shomin Bhattacharya appears for the Income Tax Authority.
Okay, on the prayer of learned advocate appearing for the special officer.
Yes, ma'am.
The matter stands adjourned till 30th 30
Grateful, madam. Grateful.
June 2025.
Grateful.
Yes,
let this G1 and G2 এই যে আগের ম্যাটারটা যেটা অর্ডার appear on 3/7/2025.
Your lordship has given 5 weeks time.
That is interim order.
Interim order. 3/7.
Interim order for 5 weeks. The matter will appear on 3/7/2020. Or you want some more time?
My lord, some more time for publication purposes, my lord. It will take some time. 2 weeks, 3 weeks time. 3 weeks time.
Okay, then 15/7/2025.
My lord, one indulgence. Can it be 16th instead of 15th, my lord?
ওটাকে 16 করে দিন।
Straight to
16/7/2025.
May I mention, my lord, item number 51. My lord, I understand, my lord, your lordship has appellate side today from 2 p.m. and my lord, there are fixed matters.
No, appellate side from 2 p.m. to 3 p.m.
Yes, and
3 p.m. there are some fixed matters
Fixed
that may not be taken up also.
Lordship, and for the plaintiff, let the matter be called because today is the day fixed for adducing evidence by them, Your Lordship.
57,
51.
51, my lord.
51. Okay, 51, you are for the
For
defendant.
the defendant, my lord, to be very candid, my lord, I have to take out an application has been taken out, but a further application is required to be taken out, my lord. We are taking steps for taking out that application.
Lordship, today the day was fixed for adducing evidence pursuant to
defendant.
an order passed by the division bench. Lordship, you was part of that order, Lordship, of 23rd December 2024, and they had given that undertaking that no
No,
further.
I have also clarified whether this bench can take up this matter or not.
I don't have any difficulty, my lord. There, my lord, the parties
So
or the
that
lawyers are
on
advised.
hearing the learned advocates and with their consent,
Yes,
I
yes.
clarified whether this bench can take up this matter.
Lordship, and today is fixed after 2 adjournments which they have already sought for, and the application that is being spoken of in my humble submission is a frivolous application, my lord, as and when the matter is called.
Kindly take it up, my lord. I would humbly beseech your lordship, kindly take it up.
What
my
is
lord.
that application?
My lord, it's for recalling of the plaintiff's witness, my lord. It's required because, my lord, that your lordship will decide whether
Lordship,
that
that
has to be.
application has not, I'm sorry, but that application has not been filed. It's
No, I said that I'm taking out another application. One application has been taken out. That, my lord, for that.
On Mr. Mitro, learned advocate for the defendant, raised for time to file an application to recall the plaintiff's witness. That application is not yet filed.
No.
Lordship, that application has not been filed yet.
I said that.
However, in the interest of justice, how soon can you file?
That is the
Because this is the government authority.
That is the whole difficulty, my lord. I was trying to, my lord, tell my junior, my lord, to expedite, but I really do not know. Can it be, my lord, so that to be on the safer side, can it be on 1st of July, my lord, so that I can, my lord, come up with that
In the
application?
interest of justice, the matter stands adjourned till 1/7/2025. This direction is peremptory.
Absolutely.
Lordship will kindly record my objection to this mentioning, Your Lordship.
আগে করে দেবেন, Mr. Mitro prays for time, which is objected by your name, please.
Mrs. Madhupriya, Your Lordship.
Ms. Madhupriya, learned advocate for the plaintiff.
Lordship.
Lordship, may I be permitted to mention?
দুটোতে তো আগে appellate side হবে.
Lordship, may I be permitted to mention next one?
Just a minute. দুটোই ওটা কি উইটনেস অ্যাকশন নয় তো, এমনি অ্যাপ্লিকেশন। এই অ্যাপেলেট সাইডটা ওটা দেখে নেবো, দুটোর সময় অরিজিনাল সাইডটা একটু ডেকে দেবেন। যদি ওটাকে অ্যাডজন করানো যায় তাহলে ভালো, তাহলে অ্যাডজন করিয়ে আমি অ্যাপেলেট সাইডটা ধরে নেবো।
Talks of settlement is going on and the interim order is expiring. Only that, Your Lordship. 29 to 33, Your Lordship.
I appear for the plaintiff, Your
Talks
Lordship.
of settlement is going on and my interim order expires today. If Your Lordship is pleased to extend the interim order.
I am the plaintiff. I'm not disputing what my learned friend is submitting. I'm simply praying that there is a different set of there's a different suit which has been fixed on 23rd, returnable at 23rd of July.
Yesterday,
Your Lordship kindly extends the interim order and keeps it on the same day. So that if
in which case 20 in all four cases,
all
of 29 to 33.
It's the partition suit, Your Lordship.
29 to 33 আচ্ছা, এই চারটে দিয়ে একই অর্ডার করে দেবেন। Learned advocates for the parties are present. Let this matters appear on
23rd of July. 23rd of July, 2025.
7/2025.
And
The
the interim
interim
order
order granted earlier stands extended for a period of 6 weeks.
Till then only, Your Lordship.
6 weeks or till further orders,
Lordship.
whichever is earlier.
Hopefully the matter will be settled, Your Lordship.
Yes.
Grateful, Lordship.
Grateful.
original side এর দুটো ম্যাটার হয়ে যাবার পরে appellate side, two fixed matters. Two fixed matters of original side, thereafter appellate sides. দুটো fixed matter আছে original side, 2 PM. ওটা হয়ে যাওয়ার পর appellate side.
Original side matters fixed at 2 PM. Adjourn motion item number 34 to 45.
Lord, I was finishing my arguments. GA16. GA16. My lord, just to give a short recap, my lord, of what I had argued on the last day, my lord. This was not a simpliciter partition suit. My lord, this was a case, my lord, which has come before this court only after, my lord, the conciliation between the 5 branches had failed. And in the conciliation, my lord, it was already agreed that each branch, which branch will get which property and run which company. There was one of the companies where there was a dispute as to whether it is a family company or not, and that property was being dealt with. Therefore, as a catalyst to the dispute regarding that one company, the suit was filed and interim order was obtained only with regard to that property in 2013. It is a defendant number 5 who was controlling this company which had that property against which the order of injunction was passed. The defendant number 5 and the company, that is defendant number 40, they were objecting to the order of injunction. They also filed a vacating application, which finally they did not succeed. They failed to obtain any vacating of the interim order in 2021. It is only after that, as a counterblast, they have filed this application. That is the history of how this application was filed. Then, my lord, so far as this application is concerned, I had shown, my lord, that the cause of action is illusory. There was actually no cause of action whatsoever. The case made out is that, case pleaded is that there are 3 companies. In these 3 companies, the additional directors have been appointed on a particular date by one director who was already there. That director had resigned prior on 23rd November 2021. Therefore, he could not have appointed directors on 3rd December 2021. And most importantly, this entire process of appointment of new directors was with a view to take control of this company and sell off the assets.
That was the defendant number 5's case.
Defendant number 5's case. That is the pleading. Argument was that the defendant number 5 has been removed as a director, which itself is wrong. There was defendant number 5's branch continues to remain a director, and in fact, what was not presented before your lordship, what was not there in the application and not brought on by any supplementary affidavit also, is that at the instance of the defendant number 5, in these 3 very companies, board meetings have been called, new directors have been appointed who are members of the branch of the defendant number 5.
You have clarified that in your affidavit.
I have clarified it. I have also, my lord, prepared a note, my lord. It's getting prepared. It's getting finalized. I'll file it, my lord. Also, my lord.
So, whether the other defendants can conclude the arguments, others are not present. So you can file your note and conclude it on the next day.
I can do that, my lord. I will take 5 minutes only. I just wanted to show 5.
And you have argued that you have clarified in your affidavit in opposition.
Yes, my lord. I just wanted all that I have is left on my part is to show 6 documents which will show that the allegation that this defendant number 17, who had
documents on record,
all on record. In fact, they are all part of the petition itself. That on 23rd of December, there was no resignation whatsoever of this director. He had resigned only on 3rd of December after
expressed his intention to
expressed his intention. That is not resignation.
That was accepted.
Yes, my lord. That was accepted. So the calling of the board meeting, there was nothing wrong in it. So, my lord, I just have to place those 6 documents and have file my notes. Otherwise, my arguments are complete.
Yes.
And the other defendants can also conclude that day, my lord.
No, you conclude it on the next day.
I appear for respondent number 1 to 4. Might kindly give me another date, Millard, so that I can come back to your lordships and Millard place my arguments.
advocate for the plaintiff opposite party in GA 16 of 2022 and learned advocate for the defendant number 5 applicant of GA 16 of 2022 and the opposite parties in this application are present. Are learned advocate for the plaintiff opposite party in GA 16 of 2022. As the hearing cannot be concluded today, let this matter appear on 2/7/2025
My lord.
for hearing and submission of written notes of arguments. 2nd of July. Yes. Yes.
Just other defendants on.
My lord, who will be placing our case on that day? My lord, the other defendant.
16 order. GA 16 to the order of it.
Complete on second
The other applications we also listed along with this case.
Yes, yes. Oblige. Oblige to your lordship.
2nd July.
2nd July.
Old suits, item number 49.
Hearing today, we also listed on 2nd July 2025. আরেকটা আছে অডিয়েন্সে ডাকা হয়েছে ফিক্স ম্যাটার 2 PM.
For 49.
$49. Yes. Item 49 and item, okay, only item 49.
Item 49, item 49. We have our making our submissions. If I come back to your lordship, I am the defendant in this for eviction. And the last petition I had presented.
Oh, Mr. Gupta argued. Oh, Mr. Kaur. Right. Oh, this was a fixed matter. Yes.
No.
Regarding, yes. Now I understand. Mr. Kaur concluded his part.
On concluded submission so far as GI.
Yes.
I was making my submission. Now, Miller, in the background of making my submission because of the last petition, I had this on eviction. Subsequently, show that the lease, with respect of which Miller was filed on 2 grounds of forfeiture of these on the ground of lottery withholding, and be unable to make construction in terms of the sale. Thereafter, Miller, after filing of the suit, twice, pursuant to orders of court and by consent of the parties, the lease could amended. The terms of the lease were altered. The rent was increased. The time to make the construction was also enhanced. My submission was that on both the occasions, the court had noticed and observed that these alterations are being made pursuant to suggestions made by parties. And the courts are accepted. So my primary contention was that since the lease was subsequently altered, the breach which was complained of in the play no more subsists.
Right.
Now, on this first application which Mr. Kaur's client had filed, GA6.
Yes.
This is not that application.
Okay, earlier application.
Yes.
Probably I think that was dismissed. No, not dismissed.
In GA6, when GA6 was filed, Mr. Kaur's contention, that was.
Yes, apex court order was not passed.
By that time, contention was
And so far as the current rent was for failure of payment of rent for the months of September to November 1985. That was the default. The court's application was that the current rent for the month of 2020 2019 onwards was not being paid. And it asked for a direction in this suit, for the defendants to pay that amount. Apropos GA6, we took out an application GA8. In GA8, our contention was that in view of the subsequent changes and developments that have taken place, not find place in the claim. The suit has lost its force, spent its force, and nothing remains in the suit. The cause of action has died. Therefore, no order can be interlocutory of an interlocutory nature to have been passed. That application GA8 was being heard first by the court. And the court was of the view that although you have made an application under Order 7 ruling, but you are inviting the court to examine the facts, subsequent facts which are not part of the claim. So, our exercise of power under Order 7 ruling, I cannot consider those subsequent and dismiss my application.
Thereafter, you preferred an appeal.
Preferred an appeal. The appeal court said that the learned judge is correct. Order 7 ruling may not have been the right process. But since you are raising the question, we goes to the root of the matter and the jurisdiction of the court. Yes, it should be heard as a criminal issue. Now, from that, we went back to the learned trial. The learned trial judge, because the question arose before the learned trial judge after the division bench order was whether to hear GA6 or whether to hear the preliminary. The court was of the opinion that the preliminary issue has to be heard first because that's the question that's required. Pending this, in the meantime, Mr. Kaur's client had gone up in appeal from the appeal court order. Supreme Court may not, no uncertain terms have said that we do not interfere with. Therefore, the observation of the division bench is a jurisdiction of the court remains untouched. And in one of the subsequent paragraphs, the Supreme Court has said that you, the plaintiff, you can take out an application in the suit if you so desire, and that will be considered in accordance with law. So that is being construed by the plaintiff, if I have understood the submissions correctly, that in effect has diluted the appeal court order, and therefore they have made an application on the same grounds, asking for the rent, the same price as GA6, only the extended portion of it has been included. Now, my contention before your lordship was that this GA has to be heard because in the order of the apex court,
that is GA?
Yes.
8.
Look, what had happened is because so far GA8 was concerned, my learned junior had yesterday mentioned the matter for your lordship. Because I will be arguing the same points which the appeal court has given me the liberty to argue. And the apex court judgment.
No, GA8 is maintainability petition.
Maintainability of the suit. And
No,
because your lordship, I am told because your lordship had already passed a direction that the GA8 should be listed. But because we don't find it in the list. But I can continue my submission for GA9. Because the scope of GA9.
No, you see, 2 points are to be argued by you. So far, Mr. Kaur is concerned, Mr. Kaur argued with regard to the merits of GA9. So far, you are concerned, 2 things. Maintainability of GA9 prior to maintainability of hearing of GA9 prior to hearing of GA8. This is the 1 point. Second is merits of GA9 without prejudice. These are the 2 things here to be. So if you want for your convenience, you come with a compilation and written notes. 2 things, that is maintainability of GA9 in terms of the order of the appeal court and the Honorable Apex Court prior to deciding GA8. This is one aspect.
Second is the merits of GA9, because you have also filed your affidavits in GA9. So two things you argue.
Yes, because on the last occasion I had given your lordship the background, but I have not shown the subsequent judgments that have been passed with very same matter by various courts. Because prior to GA9,
So bring a compilation on the next day.
the orders are not here. I have
No, if you bring your written notes, list of dates and compilation, it would be easy.
I had the last occasion said that we require a list of dates. Your lordship wants me not, we take out and make a convenience compilation.
Yes, compilation, list of dates you have filed. So convenience compilation, your submission with regard to two things, because you are insisting 8 be hard out. Okay.
Saying that, see, not the reason why I wanted to show the order that the Supreme Court said, without first saying we are not interfering with the order.
Yes, yes, I've gone through that order.
It also says that it is open to hear out the suit.
Because you see, I have also to observe, first of all, whether why 8 will not be hard out first. I have to observe upon hearing your submissions. And thereafter, come to the conclusion with regard to GA9.
Very, if you not convenience compilation.
Okay, so bring a convenience compilation, your written notes with both that regarding the maintainability of GA9 and your GA8 both. This is with regard to why GA8 has to be taken out first and then GA9.
I had heard submission.
Yes.
Probably would. In the event your lordship finds that GA8 is a question, here in GA8 was that suit be dismissed. The appeal court said that no, here this as a preliminary issue. Like this preliminary issue which I am raising in GA8, of course, we are not in GA8, the suit itself. And the Supreme Court has said hear out the suit. What I was trying to insist upon your lordship is that this preliminary issue which I have raised is a pure question of law on facts which are admitted because they are orders of law. So we are trying to hear out the preliminary issue, which was the direction in GA8 by the appeal. Because if your lordship hears out the because the question is this.
No, that I shall consider. Upon Mr. Kaur has made his submissions. So far you are concerned, I shall hear your submissions. That is your written notes as well as the convenience compilation as to why GA8 ought to be decided first than GA9. That is your ground. And thereafter GA9, your opposition and grounds will also be there.
At the cost of litigation, my was an application to mediation of.
Now it has to be reconsidered. Either to be treated as a preliminary issue or whatever it is.
That the appeal court has already
Yes.
said that it has to be treated as a preliminary.
Yes, that is reconsideration.
Take GA8 as if your lordship is hearing the preliminary issue. Because if your lordship or GA8 as it stands after the order of the appeal court, it was an order 7 rule 11. So therefore, now the preliminary issue is what the GA8 has to be heard. So can we consider GA8 as if your lordship is hearing?
Because you see, while taking a decisions, I have to observe with GA8 why I should not hear it now, or if I hear it, then definitely this has to be kept in abeyance. Either way, I have to decide.
Then in that case, kindly deny the GA8 to also appear on the list.
Yes.
But the only thing.
Otherwise, definitely GA8 will also appear, and you can also file it in your copy also in the compilation.
Yes, but since the matter is not in the list, I don't want to. So let it appear in the list.
Because the moment I come to a findings or I decide that GA8 has to be decided first, then of course by a reasoned order, then this has to be kept in abeyance, this GA9. But if I hold that yes, GA8 can be heard, then I can proceed and pass necessary orders. That is why you make your submissions with both.
But only thing, Mr. Dutt, learned senior advocate, my lord, he has already indicated and he also placed after Mr. Kaur the order of the Honorable Supreme Court. Now, so far as subject to correction by your lordship, so far as GA8 is concerned, GA8 was dismissed on merits by the Honorable Trial Court, my lord's coordinate bench, honorable coordinate bench. Thereafter, the honorable division bench, in an appeal from that order, my lord, was pleased to hold that preliminary issue may be decided and it will be open before by the honorable single bench to decide whether to hear out at that time GA6 or preliminary issue. It will be the discretion of the honorable single
Yes,
judge.
that order is there.
That order is there.
Division
Now-
bench has given discretion to the court. Thereafter, the matter went to the apex court. Thereafter, the coordinate bench has said that yes, preliminary issue has to be decided. Okay. And thereafter, this GA9 is taken out. Let Mr. Datto give his own
I'm
arguments.
grateful. Well, the only thing, the GA8, my lord, has not been restored. So, subject to correction.
GA8 is not restored means how
GA8, the order of dismissal is there.
No, 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 no,
But
no.
Mr. Dutt,
That has to be reconsidered. GA8, not as an application, but as a preliminary issue. Okay. The GA8 has to be reconsidered, not that it goes.
The contents of GA8.
Yes, yes, that has to be considered. May not be as an application,
be
but
as
as
an
a
application.
preliminary issue.
Yes.
Learned advocates, Mr. Dotto, learned advocate for the defendant.
No. Teish.
And learned advocate for the plaintiff are present. Hard learned counsel for the defendant on GA9 of 2025. It is submitted that GA8 of 2025,
23, my lord.
GA8 of 2023 be heard analogously with GA9 of 2025. Let GA8 of 2023 be put up. Learned counsel for the parties are requested to submit their written notes of arguments regarding the issue involved in GA8 of 2023 and GA9 of 2025, as well as with regard to the merits of GA9 of 2025.
My lord, only thing, my lord, it will be your lordship's kind pleasure to indicate that GA8 has already been dismissed.
No, at this stage, no
My lord,
question.
since
At this
my lord-
stage, nothing can be done. Let me hear out, okay. Let me consider hear out, and whatever observation is necessary, I shall make that.
It has been otherwise there might be a confusion that
You take it in your written notes of arguments. Take all these things.
and my lord is being pleased to direct us to come back on.
Yes, yes. Let this matter appear on 2/7/2025. আচ্ছা 2 তারিখে কোনো দুটোর সময় ফিক্স ম্যাটার আছে? 2/7/2025 at 2 p.m. Appellate site.
Your
You are
Lordship,
appearing for
the opposite party number 2, Your Lordship.
opposite party number 2, that is the yes.
Well, I'm led by Mr. Bhattacharjee, my lord.
No,
who I'm-
opposite. Just a minute.
I'm seeking adjournment in this matter, my lord.
Sir, it is a norm that they keep on giving various
My lord,
excuses.
Party Hemant.
Conviction before Hemant Garodia. My lord, the
Yes.
brother of the petitioner, my lord. My lord, I'm seeking
I'm
adjournment.
keeping it on Friday.
My lord, can it be on first day of June, July, my lord?
Sir,
Mr.
that will be
Bhattacharya
too
will
late, sir.
be-
And sir, I am in a need of
The matter of 2021, my lord. The matter has been released before at least 3
No,
bench of
maybe, but what is the assurance that on the next day will appear?
my lord, Mr. Bhattacharya
exactly,
will
sir. They
submit, my
keep
lord.
on giving various excuses, sir,
He also
just to delay the
of the matter,
proceedings
my
of the
lord.
case, sir.
Kindly grants me time till 1st of July, my lord.
State of West Bengal is served. State.
My lord, this is a
Um,
complaint case, your lordship.
Yeah, state is not served, sir.
There is no need to serve on the state,
Anyway, you
it's a
serve it
complaint
because you can serve the PP.
No, sir, I have not served because since lower court only we are not.
complaint case,
I
Your
am not
Lordship.
serving
It is
two states.
cannot
sir.
He's
be a-
made a party.
It's a revision petition. It's a old matter, my lord.
Sir, I have never
Part
been
of the
told to serve any copy to states, sir. But sir, it's a norm that that the opposite party lawyer keep on giving various excuses, sir, with the sole motto to delay the proceedings of the case, sir. Sir, sir, I am in a urgent need of an instruction, sir. Sir, a medical case, sir.
তারিখে কোনো ইয়ে আছে দেখুন তো কোনো ম্যাটার ফিক্স করা রয়েছে 3 তারিখে the name of the complainant sister.
Name of the complaint system.
Complainant sister means
Allowed to be mentioned.
yes.
The no name is allowed to be mentioned in the petition, but I
So
mentioned the name.
complainants, this is the brother-in-law of the complainant.
Mesho Moshai.
Sister's husband.
Sister's husband.
Complainant, sister's husband.
Actually, I think it's written wrong. Mesho Moshai is complainant's
Yes, complainant, sister's husband.
maternal aunt. Maternal aunt's husband. It's written wrong, I guess.
Complainant to mother of the victim.
Oh, complaint mother of the, then it's,
She mother of
Complaint
the
is the mother.
then it's. And the name is mentioned in the main petition in the envelope. It's in the case report, in the file. It's there in the envelope. The name is mentioned there. If you can, Lordship would kindly take a look at the main petition, which is in the envelope. Envelope.
And you have to clarify the complainant's sister's husband.
Yes, I have written that in the can. It's there in the
Paragraph 1.
Paragraph 1, line number 5.
Yes, record an order. Learned advocate for the petitioner accused is present by order dated 5/6/2025. Petitioner accused was granted bail. Stop. As the name of the petitioner is not mentioned in the cause title, nor it is mentioned in the body of the petition, the petitioner cannot be released on bail. Regarding
Punished bail.
yes, you are granted bail,
Granted bail.
cannot be released. Okay, what was the order of the trial court? Is it mentioned there in the cause title of the trial court's order? Because
Main petition is there.
no, the main petition, definitely main petition will be here.
Yes, in the envelope.
Yes, because the trial court order sheet.
Yes.
The main petition to me.
Okay. However, as it is clarified in the petition that the petitioner is the husband of the complainant's sister, let
If you Lordship would
the
permit to write a Mesho Moshai word, Mesho,
husband of the the petitioner is the husband of the complainant's sister, being a Meshomoshai of the victim girl and Bhognipoti of the complainant. The petitioner may be allowed to furnish the bail bond. Other contents of the order dated 5/6/2025 remain unaltered.
My lord, item number 3, my lord, came at my instance. My lord, I am extremely apologetic to your lordship. My lord, right now, my lord, as per the instruction of the client, the order is correct. My lord, I was being instructed that my lord has recorded 4 witnesses have been examined. So my lord, it is 4 witnesses have been examined. Earlier I was
Okay.
told, my lord, no correction is required. My lord, I am extremely apologetic to your lordship.
Okay. Let the matter go out of the list.
Yes, my lord. I am obliged, my lord. No.
Okay. Let the matter being disposed, let it go out of the list.
I dispose of bail application.
Lord, 4, Lord, I am led by Mr. Tanmoy Mukherjee. He is engaged in court number 4. Kindly take it up Friday. My learned senior friend.
Okay, let it appear on Friday.
Mal.
Let this matter appear on 20th of June 2025.
26 June.
20th. When do you want? 20th of June, coming Friday.
My lord,
নাহলে পরের শুক্রবার let it be on 20th, my lord, if I am not there then কোন শুরু করবে তো হিয়ারিং হ্যাঁ যদি হয় my grateful
Right.
Number 5.
Five and six also, Fulcom Bhattacharya Millard, he is on his legs in court number 552 Millard.
Okay, let item 5 and 6, let this matter appear on,
I am appearing for the.
let this matter appear on,
Friday Millard.
okay, 4th of July, 4/7/2025. I'm giving it on 4th of July after 2 weeks.
My lord can pass it over for today. He is on court number 5.
No, 3 p.m. I have another fixed matter, original site.
If
Okay, 4th of July.
For the respondent, my lord,
In this matter and substitution application was required.
that's not filed.
Okay, not today. এই শুক্রবারে এটা দিয়ে দেবেন আর কি।
Next শুক্রবার।
Coming Friday. হয়ে গেল? হ্যাঁ? এমনি থাকছে ফ্রাইডেতে থাকবে আর কি।
Friday.
এটা প্রথমে কোনটা আছে? Witness action 63 তার আগে কোথায় আছে? ও তারপরে 4 PM আছে। এটা তো 2 লাইনের ব্যাপার। হ্যাঁ দেখে
Original side matters fixed at 3 p.m. Receivers accounts item number 24.
may it please my lord.
Yes.
Now, in this matter, I appear for the erstwhile receiver. I had indicated to my lord that the erstwhile receiver kindly does not take me amiss, is not in a condition to even get out of his bed on the last occasion. My lord, we had applied for commission on a prior date. However, that fell through. We have one
representing the
erstwhile receiver.
Yes.
Thereafter, my lord, I am handing over a document.
The accounts.
No, my lord. I am handing.
Whatever the department has put up today.
Yes, my lord. I must also say that there is a new receiver appointed in the matter. Possibly that accounts pertain to the new receiver. It was incumbent upon me on a prior date to make over to my lord an affidavit pursuant to directions. That affidavit was not affirmed inasmuch as the gentleman's signature, the erstwhile receiver's signature, was never matching. On each different occasion, it was a different signature altogether. Each time we came and one time we had to get the erstwhile receiver to the court premises. It was a very odd predicament for us because we had to then rush back to the hospital. So, my lord, strict advice is not to leave his premises and not to leave his bed. He is under intensive care at home. But I have once again applied for the same to be done on commission.
Commission to be appointed by this court?
No, my lord. My lord need not appoint a commission. I have applied for the department. The oath commissioner will personally go to the.
That application is before this court.
There is no application required for that. Just a requisite has to be paid. What my document that I am showing, my lord, is the proof of payment of the requisites for the purposes of application. To my lord, I know it has been delayed on several occasions on my account. But my lord, I just want to tender my bona fides before my lord.
Today the matter is appeared. Today is for receivers account.
Receivers accounts. Since I am the erstwhile receiver, I had when given my affidavit, there was an exception to, and they had taken out an application saying that the accounts submitted by me were incorrect or misplaced. I took an opposition to that because I say that the accounts are not incorrect and they are not misplaced. But this opposition that I attempted to take out, my lord, I could not I have not been able to have it affirmed. I have finally applied before the honorable department. My lord. They have taken all my requisites required, and it shall be done on commission. My lord, may I say this, my lord? If my lord so permits, with respect to my affidavit in opposition, kindly grant me a period of 4 weeks, my lord. The situation is such, my lord, I cannot point a finger down and say that it will happen within a period of 1 week.
This is the present receiver's account.
Yes, possibly, my lord. I am not privy to that. Neither am I related to that.
এটা কবে রেডি হয়েছে?
লাস্ট অর্ডারটা দিন না, যেখানে আমাকে বললো।
প্রেজেন্ট রিসিভারের। আচ্ছা আচ্ছা। যাই হোক, এটাও তো একটা অর্ডার করতে হবে, পেরিউজ দ্য প্রেজেন্ট রিসিভার্স অ্যাকাউন্ট। হ্যাঁ, একটা অর্ডার করি, ওটা যখন করছি তাহলে এটাও একটা অর্ডার করতে হবে। আচ্ছা, অর্ডারটা
On the last 2 occasions also, my lord, I have not been able to furnish my affidavit.
Yes, record an order. Peruse the present accounts submitted by the present receiver is perused. Learned advocate appearing for the former receiver is present and submits that due to serious illness of the learned receiver, his signature on the affidavit could not be obtained, and as necessary requisition is already made for examination by commissioner, let liberty be granted to file the affidavit pursuant to deposition before commissioner after a period of 4 weeks. The prayer of the learned advocate is allowed. Let steps be taken to affirm the said affidavit and file it after a period of 4 weeks. Let this matter appear on 15/7/2025.
May I say this? It will be unfair on my part not to say this. GA 12 and GA 13 are in respect of which my affidavit was called for. GA 14, I have no role to play, my lord. For my part, GA 14 need not stand over.
GA 13 of 2024.
13 of 2024.
GA 13 of 2024 and GA 14.
GA 12, my lord, of 2023.
GA 12 of 2023. This order.
Yes, আমি কমিশনের জন্য অ্যাপ্লাই করেছি ভদ্রলোকের সইটা নেওয়ার জন্য। ওইটা এখন বলেছে ওরা 2 সপ্তাহ লাগবে যেতে। এটা আমার
Your Lordship, I see that the
Item
petitioner is
5.
Yes.
The petitioner is not represented today. Your Lordship kindly keeps it on any other day.
This is just an opportunity to file, because it will not prejudice your rights, because he is seeking to file the affidavit in opposition after 4 weeks. That opportunity is granted.
কিসের উপর একটা GA 12 হয়েছিল আমার এক্সেপশন, আমার এক্সেপশন নেওয়া হয়েছিল, ওই রিপ্লাইটা আমি এখন অবধি ফর্ম করাতে পারি। GA 12 এর GA 12 এর সাথে কোনো সম্পর্ক নেই, GA 14 এর সাথে কোনো অর্ডার হচ্ছে না।
ওই শুধু ওটা affirm করার জন্য। Very well, Your Lordship. Your Lordship is keeping these matters on.
Let these matters appear on 15/7/2025, because he requires some time.
But Your Lordship, that may be that he requires some time. If it can be kept on any prior date, Your Lordship, because Your Lordship kindly remembers these applications were made by the petitioner, which we are also supporting because we have a share in those
What is the
properties.
exigency that
Because not with regard to this matter exactly. এইগুলোই শুধু appear করছে or your matters?
আজকে
Because
13 14 appear করছে।
because GA 13 and 14, Your Lordship, beyond this application also, we have, an application was made. One was with regard to the KMC,
Wait, let us
which is
do
why
one
I'm,
thing, you see,
which is
let
why I'm
this
saying,
let this matter appear on 15th. If you have some urgency, you mention it with regard
which
to
is,
the other
your lordship,
applications.
may I only?
Yes.
The reason why I'm beseeching your lordship is this: he is requiring time for the commission to happen in order to get the
Affidavit.
affirmation done of the affidavit in opposition. I am not standing in the way of that. But the other applications,
Mention tomorrow, it will be listed. So for this application, so here is for GA 13 and 14.
No, my lord.
No.
GA 14, I am absolutely unrelated.
No, this is GA 13.
GA 12 and 13, my lord.
Acha,
GA
this
12
order,
and 13.
this order is GA 12 of
2023, GA 13 of
GA 12 of
2024.
2023 and GA
13 of 2024.
GA
Further, my
13
lord,
of
GA
2024. So this is confined to these two cases.
GA 14 is not even
With
appearing
regard to
today.
your application, you
The
mentioned
GA
tomorrow.
14.
You mentioned tomorrow, it will be
GA 14 is not even appearing today.
whatever it is. Let him mention upon notice.
Very extremely obliged.
Item number 25.
I have no instruction.
Lordship, I'm the administrator in this matter. On the last occasion, I had mentioned that I was praying for discharge. The Lordship had directed the department to file their report whether administrators' accounts have been filed, is up to date or not. Lordship, I have filed my accounts.
You are the
I'm the administrator. I'm praying for discharge on personal grounds.
You have served copies upon the other parties. Served notice.
Lordship, I've not served, but they were aware of it. Because when I had mentioned this matter, I had served the copies upon the parties.
This one. The money accounts are all submitted. আরেকটা দিয়ে দিই
Hopefully furnished is up to date. You were appointed in June 2015, probably.
April 2015, 20th April
Let me
2015.
see the order. Just a petition ta din. Yes, I perused the accounts submitted.
Just one indulgence, my lord. Since January 2021, I have not taken any remuneration. If that can be accommodated, if the parties may be directed.
The fund is.
I'll just tell you, the fund is around 73,294.
73,294. It is the fund lying.
Lying. And my remuneration is coming to around 1,83,600.
And the fund available is
73,294 and 2 paise, 0.2 paise.
so you have to receive the remuneration from the fund.
Lordship. But no specific direction was.
Yes, which page? The order appointing you as the commission. You have filed your petition. Let me take up the petition. GA.
I have not my lord, that I want to withdraw that application.
No.
This, GA 06, I'll tell you, it's basically when I was the administrator, I had made this application because the building was in bad condition. The structure was falling down. The tenants there intimated me for that, for some repair work. The funds were
Yes,
not.
because let me see the order by which you were appointed.
That is of April 20th April 2015.
So you have sought your discharge by filing this application.
I have not filed any application. I had
How
just
will it-
mentioned the matter before Lordship Honorable Justice Krishna Rao. He had kept the matter
Because you see,
in the list.
if I discharge you, definitely. If I discharge you, I have to appoint some other.
Lordship, what I can do is, my lord, if your lordship directs me, I'll intimate both the parties, and then they'll.
No, I can do one thing today, grant you liberty to file application and specify your remuneration for the time being without prejudice.
If your lordship directs, although it's not required.
No, regarding application, because if you file an application, that is to be served upon the parties. Because I will discharge you and have to consider appointing some other party. So these orders are to be passed in the presence of the parties, okay? Otherwise, they will not be aware. They have to take steps also to maintain this property.
Instead of filing an application, if your lordship directs me, I'll serve the order copy on the parties and ask them to
No,
appear.
let it be specific, okay? And how much remuneration you last received?
3,400, it's monthly.
3,400 monthly. From when it was last paid?
December 2020.
So it was to be adjusted from the fund.
Yes.
December?
That's what, December 2020.
December 2020. That means 4 years.
4 years, 6 months.
73,000 is lying.
73,294.
Yes, record an order. You are the you are.
I am the administrator.
Oh, you yourself is the administrator.
And I'm praying for withdrawal of GS6 as not pressed.
GS6 is
Of
your
2020.
application.
It is my application.
GS6 for?
Of 2020.
No, for? It was for?
It was for Lordship, there was some.
GS6 is not here before this court. Anyway, you do one thing. You come with that application and withdraw that GS6 also.
Lordship.
Learned administrator, give your name also, is present in court and prays for discharge from this case. It appears that the learned administrators have submitted the accounts with regard to the administration of the estate of the deceased. as necessary application is required for necessary decision and service of notice of the application is also necessary, learned administrator is granted opportunity to file necessary application and cause service upon the parties to this case in the meantime. As the remuneration was last received by the learned administrator till December 2020, and at present rupees 73,000 is lying.
294.
73,000?
294 and 0.02 paisa.
73,294.03 paisa.
02.
Point?
02.
02 paisa is lying in the fund of the state. Learned administrator be paid remuneration from the said fund, may receive remuneration from the said fund of rupees 25,000.
Gotcha.
25,000
Gotcha.
without prejudice. Upon taking steps of filing necessary applications, the learned administrator, upon causing such notice, may mention the same.
Lordship, I'm grateful.
Or shall I keep it after 4 weeks or 5
Lordship
weeks?
keeps it after 4 weeks.
Let this matter appear on 16/7/2025.
Lordship, kindly
16th
make,
of July.
Lordship. Lordship kindly makes it on 17th of July.
Okay, 17/7/2025.
I'm obliged.
সেটা কল করে দিন এবার।
Witness action, item number 63, fixed at 3 p.m.
Lordship, I beg to appear on behalf of the defendant number 123. Lordship, I've been instructed to seek an accommodation before Lordship. As
Yes, you are appearing for?
defendant number 123. Lordship, the DW3 was.
No, today is fixed for the examination of whose witness?
DW3.
DW3.
Yes. Lordship,
He has not turned up today.
Lordship, unfortunately, he's suffering from tuberculosis of spine. For that reason, he's completely bedridden. He is unable to come to the court, Lordship.
Yes.
Somebody's health, I cannot say.
No, I
But it's,
suggest
yes,
a date.
no, only it's not that suggestion, my lord. First of all, my lord, this matter, from time to time, diverse dates were taken on the ground of difficulties of respective witness of the defendant. In this matter also, this witness is concerned, this is the second or third time.
DW3.
DW3. So, my lord, this will go on. And the nature of disease.
The thing you see.
Commission.
If he is suffering from illness, I can do one thing. You can apply for appointment of commission. I can appoint a commission.
Well, that is what I'm going to submit.
Yes.
The nature of illness which he has said from this certificate,
maybe
it cannot be cured within 1 week or 2 weeks'
So
time.
let there be an appointment.
Yes. So therefore, my lord, even for that purpose, no formal application is necessary. Lordship can appoint here and now.
So he did not take the trouble to come to court. He is a resident
I agree
he's
with
a
that.
resident of Calcutta.
Yes.
No problem. Let the commissioner be
Lordship,
appointed.
Kindly appoint.
Lordship, one small indulgence. I am not the advocate on record, Lordship. So I have been instructed to seek an accommodation as he is unable to come.
Let it be not today then. Let it be not today. You tell him to come tomorrow to be mentioned.
Lordship, I am also instructed that if the matter can be kept after 15 or 20 days, Lordship.
No, there is no guarantee, my lord. Kindly don't do that. In this way, the matter is being lingered for the last 4
No,
years.
it is an admitted position that he is ill.
Yes.
Okay.
I am not disputing that. I am
Yes,
not
record an
disputing.
order. Learned advocates for the parties are present. today is fixed for further examination of DW3. It is submitted on behalf of the defendant that DW3 is suffering from illness and he will not be able to come to court within a short period. Considering the fact that the case is pending from 1999, this court is of the view that a commissioner be appointed to examine DW3. I thus appoint Dash as the commissioner. So commissioner's expense be shared by the parties?
Yes, but it is at his instance. So therefore, the
Let it be
commissioner.
shared, let it be shared by the parties.
I am not in. It is at his instance. The commission is.
No, it is at
required
the court's discretion. Let the remuneration of the commissioner be shared by the parties.
কোর্ট বলছে দিতে দেবো নাকি আবার?
Let this matter, learned commissioner upon notice
কমিশনারের
shall
রেমুনারেশনটা শুধু আমাদের শেয়ার
take deposition of learned commissioner shall upon notice to the parties and their advocates take deposition of DW3 within a period of on or before 1/7/2025. Let the report be submitted on or let the report be submitted on or before 7/7/2025.
May I know the dates as your lordship said, Malad? I just missed it.
So the deposition shall be taken. কি লিখলাম বলুন তো ওটা?
বলে দিচ্ছে।
Yes, upon notice to the parties and their advocates, take the deposition of DW3. Yes, on or before 1st July 2025. On or before.
My lord.
And the report shall be submitted on or before 8/7/2025. Let this matter appear on 10/7/2025 for report of the commissioner.
My lord, as far as the remuneration of the commissioner is concerned, as your lordship has suggested, we will share one. The rest of the cost to be borne by them.
Yes.
My lord, make it clear. Kindly make it clear.
Incidental costs.
Incidental cost.
Okay, incidental cost shall be borne by the defendant.
Incidental cost. Excepting the remuneration of, my lord, make it, kindly make it clear.
I made it. Incidental cost of commission shall be borne by the defendant.
Yes.
হ্যাঁ বাকিগুলো কবে থেকে কবে adjournment কত হয়েছে লাস্ট 45 ইমেজে ছিল এটা এটা তো adjourn হয়েছে সুট adjournment কত ছিল 45 ঠিক আছে দেখে দিন বাদ বাকিগুলো
Adjourn motion, item number 46.
Shankar Banerjee is in this matter. I'm praying for not today. He's
not today.
Not today. Much.
Yes, next.
Testamentary matters, item number 47.
Yes, not today.
Item number 48.
Yes, not today.
Old suits, item number 50.
Your Lordship, I appear on behalf of the plaintiff. I am praying for not today, Your Lordship.
My lord, I'm on behalf of the defendant.
Item 50. Yes. You are not appearing all along. It's a 2000. When can you come?
Your Lordship, the advocate on record is not well, Your Lordship.
My senior is not
I'm
well.
adjourning it for a period of 3 weeks.
I am grateful, Your Lordship.
But you must come ready on the next day.
I am grateful, Your Lordship.
Item 50.
I'm grateful, my lord.
Learned advocates for the parties are present. On the prayer of learned advocates, the matter stands adjourned. Let the matter appear on 3rd of July 2025.
I am grateful, Your Lordship.
Item number 52.
52.
That item number 52, I beg to appear on behalf of the plaintiffs, my lord. But this matter has come up after the change of the advocate on record, my lord. On the last occasion, your lordship was pleased to direct to serve the defendants and also the advocate on record who was appearing
For
on
the
behalf of the
defendants.
defendant. We have caused service, my lord. My lord, there is a history of this matter. Maximum of the defendants have been marked as ex parte. Now, my lord, before this matter came before your lordship's determination, it was taken last by Justice Sugato Majumdar, when his lordship was pleased to direct for substituted service by a newspaper publication. So, as per the order dated 4th April 2024, newspaper publication has been made, but the affidavit is ready, but it was not submitted before your lordship. So, let the affidavit of service be kept with the record with your lordship. And as far as the two defendants, which are defendant number 2A and 2C, in respect of whose defendants the substituted service has been made, let them be also declared as ex parte. Because only the contesting defendant.
Justice Majumdar's order.
My lord. আচ্ছা, এখানে annex করা আছে।
Yes, there was a direction to cause substituted service, and you have caused the substituted
Yes,
service.
this is the affidavit to that effect, my lord. My lord, no one turned up.
With regard to which?
With regard to defendant number 2A and 2C.
2A and 2C.
Because if my lord goes through the earlier orders, already the defendant number 2B, 1B, 1C, 1D, 1E, 1F, they have all been made ex parte.
2A, 2B, and 2C. So these three defendants are served by substituted service.
Yes, my lord.
Yes. When was the date fixed for substituted service?
My lord, the matter was directed to appear in the list on 15th May 2024. But thereafter, the matter did not appear, my lord, and when the matter appeared, there was a change in the advocate on record. The erstwhile advocate gave a change, my lord.
Yes, record and order. Learned advocate for the plaintiff is present. In terms of order dated 4th April 2024, the plaintiff has caused publication in the newspaper with regard to service of defendant number 2A, 2B, and 2C. As none have appeared for the said defendants. No, the question is, I can seek a report, or you can also seek a certificate as to whether anybody has represented.
Well,
this
it is better to call for a report from the register, because
none, as none of the said defendants have appeared, learned advocate for the plaintiff is granted an opportunity to obtain a certificate from the registrar, from the department.
Well, if your lordship is pleased to call for a report from the registry.
Both, I can do that, and I can bring you
because in the event the advocate is directed, the liberty is given, and that will take some more time. If your lordship is pleased to call for a report,
let a report be submitted as to whether defendant number 2A, 2B, and 2C have entered appearance in this suit.
Well, 2A and 2C. 2B was already marked ex parte.
Whether defendant number 2A and 2C have entered appearance in this suit. Stop. Learned advocate for the plaintiff is also granted opportunity to seek necessary certificate from the department.
Grateful.
Let this matter appear on 2/7, 2nd of July 2025 for report and further orders.
My lord, it will further appear from the orders passed, my lord. In one of the orders, it has been mentioned that defendant number 1, I have refused to accept the summons.
It's a good service. Only this 2A and 2C was
but
left.
The difficulty is 1I has not been marked ex parte.
It will be marked on the next day.
My lord. Grateful.
Item number 53,
Yes, not today,
54,
not today,
55,
not today.
item number 56,
Yes, not today.
57,
Yes, same,
58,
same.
item number 60,
Item 60, yes, not today,
item number 61,
not today.
witness action, item number 62,
My lord, my witness is present today. I am for the defendant. Only thing, my lord, this matter, today the matter is, which is appearing is CS 772. This matter has always been appearing, my lord, along with CS 435, my lord, between the same parties.
Who is for the plaintiff?
My lord, plaintiff is not there in the court, but the other suit, which is CS 435 of
No,
1985.
evidence of this suit is.
My lord, common
taken.
evidence in both the suits.
Okay, give the slip, let it appear on the next day.
Well, I'll give the slip, my lord.
Yes.
Let that matter also appear along with this matter, my lord. And our witness is also present, my lord. Adil. My lord, the plaintiff has come, my lord.
Lord, I'm for the plaintiff. Lord, I need small accommodation.
Yes, learned advocate for the parties are present. You are for DW1.
I am for defendant, my lord.
DW1 is present.
DW1 is present, my lord, in person.
Okay, DW1 is present.
DW2, my lord. DW2.
DW1 or DW2?
Lord, it's DW2. DW1's witness action had completed long time ago, my lord. There was a limited point for a limited issue which had been framed with regards to registration of the partnership firm. We had filed an application on which DW2 has been called to come in the box to depose. Examination in chief complete. DW2 is present.
DW2 is present as CS number. What is the CS number?
CS number 435 of 1985.
Okay, CS number 435 of 1985.
And my lord, I'm for the plaintiff in CS number 772 of 1985.
As CS number 435 of 1985 is due to appear along with CS 772 of 1985. Let both the suits appear on the next date fixed. Let this matter appear on 3/7/2025.
Lord, for witness action under the heading.
Under the heading witness action.
Yes.
item number
Lord,
64,
Lord, it will appear at 2 o'clock. Witness action.
Under the heading witness action.
64, Lord, I am Lord for the plaintiff, Lordship.
Yes, 60?
64. Lordship,
Yes.
if your Lordship kindly give some passover, Lordship, our counsel Miller.
Yes, Mr. Ghosh, you are appearing.
Yes, yes.
I'm in this matter.
I am led by Mr. Ghosh.
Your
And
Lordship-
your witness is present.
Yes, my lord, the witness is present.
Mr. Chaudhary, Mr. Chaudhary has not come.
Yes, my lord, I don't find him, but before, my lord, the witness action starts, your lordship will recall, Mr. Chaudhary was having objection with regard to my putting questions on certain documents, which are admitted documents. It was Mr. Chaudhary's case that, my lord, we had brought before your lordship the affidavit of admission and denial, which was filed by his erstwhile advocate on record, his client's erstwhile advocate on record. It was Mr. Chaudhary's contention that his client had not signed the affidavit of admission and denial, and as a result of which, whether his client would be bound by that admission. To that, my lord, my submission would be, your lordship knows that any document which is admitted by a party need not be proved by the other party. My lord, that is the very purpose for which, my lord, your lordships always call upon us for filing affidavit of admission and denial, so that, my lord, the scope of the examination is shortened. My lord, any document which is admitted automatically goes as an exhibit. That is what the usual norm has been. So, my lord, I was humbly beseeching, before I start with the examination in chief,
if your lordship would be pleased to call upon us to satisfy your lordship as to whether those documents which have already been admitted by them requires to be proved formally by my witness or not. My lord, if that, my lord,
That you can take out a formal application
my lord,
from your side.
that is, my lord, with respect, that is the legal position. If your lordship would kindly allow me to place those legal provisions, my lord, that would make things clear. Everything is on record. There were various orders passed by this honorable court from time to time when the suit was being heard, pursuant to which the parties filed their respective affidavit of admission and denial. It is not that it has come all on a sudden. On the basis of those admission and denials, my lord, we have prepared our examination in chief. So once your lordship puts an end to this, my lord, it will be helpful for us to proceed with the examination in chief. Lest, my lord, we would not know. Every time we will put a question on any document which is admitted, they'll raise.
Okay, then let me.
But those happened, my lord, those objections were for different reasons. We objected only to the framing of the question.
No,
but
that
just
is
because
exactly my argument. You were not there.
Yes, yes.
My argument before my lord, if I may just say as to what had happened, my lord is to ascertain as to whether the documents,
admission and denial has
whether
been
you have the documents which have been admitted by your clients, whether it requires to be proved by me at all or not. My case would be before my lord that the Indian Evidence Act says, Section 58, that any document which is admitted need not be proved at all.
While that is correct, my lord, but
Not be proved. If
there's
that
a
is
reason,
so,
my
my
lord,
lord,
I have a right
No,
of
you can also
cross-examination,
seek
my
to
lord.
dispense with the formal proof.
I'm
You can,
obliged.
you can also seek for that by way of
But my lord,
necessary
my right
application
of
to seek
cross-examination
to
will remain.
dispense. You
My
can
lord,
seek
by-
dispensation of the formal proof.
My lord, my humble submission there would be, if I can satisfy with the provisions, my lord, I may not be required to file a formal application. Because, my lord, your lordship would kindly appreciate this. My lord, the documents which are before my lord
Yes.
are all filed before this honorable court pursuant to various directions passed by this honorable court from time to time.
Yes.
It is recorded that their learned advocates were present at the time when the affidavit of admission and denial was filed. Well, admission of denial and objection, affidavit of denial and admission is a provision which is there in the Code of Civil Procedure. My lord, when that is complied, what is the course that will be
My lord, on
followed?
the last occasion, sorry.
What is the course that is to be followed as per the Indian Evidence Act? My lord, this is simple legal provision. And my lord, as to whether they now can raise the point that their client has not signed, because it was their erstwhile advocate in record who was representing before this honorable court as their agent. I would be fortified with judgments which show that, my lord, when an agent is being given the authority to plead on behalf of the client, his, my lord, actions will bind the agent.
Otherwise, I can do one thing. You may examine in your own way. If they raises an objection, I can, as it is done, that stated by way of any
My lord,
application.
if I may assist your lordship.
My lord,
Why it
one
cannot
thing,
be?
Until, if your lordship so feels, my lord, we'll make an application. My lord, may I just,
Let them make an application if they are serious. I would just
My lord, on the last occasion, with regard to this issue, Mr. Chaudhary had submitted that, my lord, whatever the application may have been, this is a submission which is being made today, but as it happens, my lord, I have taken instructions from the erstwhile advocate who had filed the affidavit of admission and denial.
Yes.
He says that an affidavit of admission and denial in the affidavit form was filed, but the one that my learned senior friend had produced on the other day, that we had objected to because we were not saying that it hasn't been filed, but
On
maybe
the
that
next-
particular
on
copy.
the next day, before putting any questions, you have to be cautious. Whatever, now if you consider that, yes, whatever it is done, it is filed. Affidavits of admissions have been filed. Now it is no more necessary. But at the time of cross-examination or
I
objecting
understand.
to the examination in chief, if some questions are raised, then you have to justify that.
Of course, my lord, we shall
and as such, my lord,
address
if
your
your
lordship on
lordship
that.
recalls, their defense has been struck off.
Very well. I
So
have
the
only
case that
Only they have to
only
confine themselves to
cross-examination.
cross-examination.
Whatever is there in the plaint,
Yes,
whatever
yes,
is
only
there on
with-
record.
Yes.
No, I was humbly beseeching this, my lord. Before I start with the examination in chief, if your lordship will decide on this as to whether at all.
I can decide on your application, nothing beyond that. When you seek some decision by formal application, then only the court is empowered to decide. Or when an objection is raised, whether to allow or to disallow that objection.
Then let them, my lord, with respect, if they are objecting, then your lordship will give me an opportunity to explain that their objection itself is not tenable in law.
Court will decide only when an objection is raised, or when you seek an application, that this be decided.
In the meantime, my lord, because this is an old suit, my lord, we had a changed briefs. There are certain documents which was not with us. In the last occasion, my learned senior had also indicated that the affidavit of admission and denial, that the one they are relying upon, that was not in the proper format. So if that and the erstwhile advocate had indicated to me that it had been filed. So in the meantime, if we can inspect the records also to find out whether
There's
a
an
proper
order from the
formatted.
Supreme Court that the matter is to be over within 6 months.
I don't.
It's for 3 months. The matter was, your lordship will kindly on this ground.
There
will not
hasn't
give
been
some-
any lax on.
Yes, but there's an order of the Honorable Supreme Court that it should get over by within 3 months.
This matter.
6 months, yes.
6 months.
6 months. Yes, my lord.
My lord, I am not seeking for an adjournment, my lord. I thought today the examination would continue. So, my lord, I am not saying if my learned friends want to come up with an application, we will.
No, we would not, because it's a pure
Whatever you
question
want
of
to
law.
expect, you serve a notice as per the rules. Whatever is permissible will be permitted.
Very well.
Always take inspection.
You give a requisition, serve a notice, whatever you want to do.
Your lordship
Very
will
well.
keep it as soon as possible, subject to your lordship's.
Witness comes from outside. He's
Yes, because the witness is an outstation witness. He is above
80. Around
80.
He's 80.
Okay. Learned advocates for the parties are present. Hard learned advocates on certain issues. The examination of PW1
Yes, my lord.
is deferred till
The witness is here till Tuesday. If your lordship will be pleased to accommodate within Tuesday, my lord, if it is possible. Or else again, he will have to come.
next Tuesday and Wednesday. There is some uncertainty whether this bench will sit or not.
Oh,
some uncertainty. Otherwise, I can give it on Tuesday, but
Monday.
there is some
if
uncertainty.
it is possible on Monday, my lord. If it is possible.
Monday, Tuesday, Wednesday, 2 or 3 days. There is some.
Then, my lord. If it can be this Friday, my lord, any day, if it can be done before the witness.
So I can keep it on Thursday also.
As your lordship pleases, yes.
Day after, my lord.
Yes, day.
Yes.
Let this matter appear on
19th Thursday.
18,
18th.
19, 6, 2025. আচ্ছা 3টের সময় কি আর অন্য আছে 19 তারিখে 3টের সময় একটাই আছে আচ্ছা থাক 3টে at 3 p.m.
Very well, my lord. Grateful.
Till 19/6/2025. Let this matter appear on 19/6/2025 at 3 p.m.
Obliged, my lord. Deeply obliged.
এখন কি জানতে পারি আটকে আছে স্যার ও ক্লার্ক নেই আমি জানতে পারছিলাম না
For framing of issues, item number 70.
Okay, not today. Yes, item 70.
I appear for the plaintiff, my lord. This is a suit for eviction of 2 menial employees of trust. The suit is long overdue for final hearing. Now, after the issues have been framed.
Witness action?
No, they have taken out an application after 6 months. GA6, the application for extension of time to file for discovering fresh documents on their behalf. Discovery was completed many times
this
back.
way, this application cannot be taken up. Let it appear.
No, I filed, your lordship gave me direction to file affidavit in opposition.
So let it be taken up in the morning. Okay. This GA application, why you have to wait for the whole day? Let it be taken up any day in the morning.
What I'm submitting, after filing the application, they are not appearing. Just
whatever it is necessary, orders will be passed.
Yes. And I have filed an opposition, I have served, they are not appearing.
No reply filed.
No reply filed.
Actually, next week, 1 or 2 days, there is some uncertainty.
After that, your lordship fixes.
I can do one thing. It's
kindly record on the last occasion, nobody was there. Today, nobody is here. They have not filed affidavit reply. Kindly record.
Another thing, you see, this Why this matter will appear is at the fag end of the day. This GA
Yes.
application will be taken up in the morning.
Yes. My lord, if your lordship fixes any day, what I am beseeching is that kindly record that they were not here on the last day and today.
Record an order.
Last date copy.
Learned advocate for
13th May, nobody was there.
Plaintiff is present. None appears for the defendant. Although the defendant has filed application GS6 of 2025.
They did not appear on 13th May. I filed my affidavit in opposition. They have not
This,
appearing today.
application GS6 of 2025 appear on 2025.
Probate 26, madam.
20th of June.
My lord,
under the heading new motion. Under the heading new motion. 20th June 2025 under the heading new motion.
Very well. Obliged.
Witness action, item number 65.
কোথায় আছে? চারটের সময় ম্যাটারটা এখন কেউ আছে চারটের ম্যাটারে? আচ্ছা, চারটের ম্যাটার তো তাহলে এক কাজ করছি আমি, তাহলে 10 মিনিট পরে বসছি আর কি। ঠিক আছে, ইয়ে কোথায় গেল? আর ইয়ে
My lord, may I mention one matter, my lord? I'm extremely sorry.
Yes.
My lord, item number 62, your lordship's direction was to, my lord, intimate the official liquidator.
Yes.
My lord,
Today the defendant appeared, okay?
My lord, in this matter, my lord, may I hand over a copy?
Take steps because none is appearing for the official liquidator.
No, my lord, I'm extremely sorry, my lord. This matter has been transferred to the NCLT and official liquidator was discharged. My lord, this is the order of the Honorable Justice Sugata Mujumdar, my lord. Kindly see.
Because I have already passed an order. When is the next date fixed? এটা কবে ডেটটা দেওয়া হয়েছে? এই this item 62. I've kept it on 3rd July. You please
Very well, my lord. I shall
take the trouble to come.
Very well, my lord. Because my lord, the
advocates, the defendant's advocate appeared today.
My understand, my lord, the official liquidator office has been shifted to my lord, the new town. So it is very difficult. There is no Wi-Fi. There is no telephone number, my lord. It's very difficult.
Several orders were communicated. Nobody turned up.
Yes, my lord.
So that is why I had no other.
I had personally talked with the immediate, because today I have received this copy of your lordship's order served by the learned advocate of the plaintiff, and immediately I contacted with the official liquidator, and he sent me, my lord, through WhatsApp this order that since the matter has been, my lord, disposed of, sending there with the NCLT. So official liquidator's function has been discharged.
So I shall do one thing on 3rd July.
Very well, my lord. I shall
3rd
come
July,
and
I shall pass the necessary orders. You can collect today's orders also. But anyway, on 3rd July, the matter will be there.
I'm deeply
on your submission, or if the other side is present, well and good. Otherwise, I shall pass necessary orders.
I'm deeply obliged. I'm sorry, my lord.
আচ্ছা, আমি 4টের সময় তাহলে এসে আরেকবার বসছি আর কি, হ্যাঁ।
5 না কত নম্বর 65 না কল করবে নাকি
Witness section, item number 65.
But pursuant to on my lord's last direction that was given, your lordship, I am submitting this affidavit of service. Notice to the other side, my lord, they have duly received it. My lord, it is there in the form of an affidavit. Now, my lord, as I indicated on the last occasion, that my lord, the witness is my lord bedridden.
Let me see.
82, 83 is
No, regard you are for
I for the plaintiff.
plaintiff.
Yes. And he's octogenarian, my lord. He's bedridden for the past 3 to 4 months, my lord.
So you see, if the person is bedridden, there is a provision for appointment of commission.
Absolutely, your lordship. As I've indicated on the last occasion, your lordship.
You are for the plaintiff.
Yes, my lord. And
Now your witness is bedridden.
yes, he stays in Salt Lake, my lord, outside the jurisdiction of this honorable court. Now, my lord, whether and
This is your application.
my lord, this is my affidavit of service, my lord.
Oh, affidavit of service.
Last occasion, there was a direction upon us to serve a notice on the defendants, my lord.
So did you take out a formal application?
I have not.
Yes, record an order.
Actually, I'm just waiting for the council to come. Actually, this matter relates to commercial transfer of shares. So that we wanted to just share.
You are representing whom?
The advocate on record.
You are advocate on record for?
Defendant number 1, 3 and 3, 4 and 5.
Anyway, necessary application is not before this court.
1, 3.
It is this matter is also going on for the last so many years.
Yes. And it was. It has
Yes, learned advocate for the plaintiff is present. It is submitted by the learned advocate that plaintiff number PW.
PW2, your lordship.
PW2, who is to be examined, is bedridden and is 80 years of age. In the facts and circumstances, this court is of the view that there should be an appointment of commissioner for examination of PW2. Thus, Dash is appointed as the advocate commissioner to take the deposition of PW2. The learned advocate commissioner shall take the depositions upon notice to both parties and their learned advocates. On or before 2nd July 2025.
2nd July.
The report shall be submitted.
If my lord kindly extend that, your lordship.
No, it is the commissioner to take the deposit. Where he resides?
Salt Lake.
Okay. Okay, on or before 5th July 2025. Yes, I am passing an order because PW2 cannot appear. I am appointing a commissioner.
Very well, my lord. I must also bring to my lord's attention, my lord.
Yes. The commissioner shall take the deposition on or before 2nd July. 2nd July. And the report shall be submitted to this court on or before 5th July 2025.
Yes, my lord.
And the report shall be submitted on or before 11th July 2025. Let this matter appear on 15/7/2025 at 4 p.m.
My lord, only for the interest of justice, I'm just indicating, my lord, the subject matter of the suit, my lord, is a commercial dispute, my lord.
Anyway, let the deposition be taken. Thereafter, you come with an application. Okay, you come with an application. If it is necessary, I shall release the matter after the deposition is taken.
Very well, my lord.
Because these so many years it is pending, the depositions are being taken. After it is taken, you come with an application.
Very well.
Whatever orders is necessary to be passed, I will pass it.
Very well, my lord. I'm very.
Yes, cost of the commissioner be shared equally by the parties. Yes, the remuneration of the commissioner be shared equally by the parties.
Lordship. My lord, the affidavit of service be kept.
Affidavit of service be kept with the record.
Deeply obliged. Deeply obliged.
এই বইটা নিয়ে তো বলো